May please lordship. Matlab, I on behalf of Mr. R-Day, he's out of station lordship. Item number 7. Can it be fixed in next week lordship? Any date?
Mr. Hendrik, learned counsel, appearing on behalf of Mr. R.D., learned conducting counsel for the petitioner, price for listening the matter after
On next week lordship.
1 week.
Okay. Lord, can we fix it regarding
on behalf of respondent number 3 and 6.
are you already
Number 3 and 6. Okay.
May I please, your lordship? My lord, I like to mention an IA for unlisted at PM lordship against lordship. In fact, yesterday lordship had permitted, but that matter could not be listed today lordship. So my colleague, my Mr. Beranto, he has.
I made a mention yesterday, if your lordship recall, madam. I like to mention item number 32 with the consent of the petitioner.
Item number
32 lordship.
32.
I've taken consent of the petitioner to his present lordship. I think 3 weeks time may be granted lordship.
On 4th, my lord, 4th June.
The date may be fixed after 3 weeks lordship.
Item 32.
32 lordship. After 3 weeks lordship, a date may be fixed lordship.
Mr. Towilder, learned counsel for the
Order respondent lordship.
respondent
Lordship.
with consent from the other side, price for listening the matter after 3 weeks.
That may be fixed on 4th, my lord.
6 June?
Oblige that.
May I please, your lordship, with the consent of other side, I beg to mention item 34. Some process is going on, so matter may come on 4th of June or 2nd of June, if
Sir,
possible.
your good name.
JP Borwa on behalf of B. Purkast.
Mr. J.P. Borwa, learned counsel, appearing on behalf of Mr.
B. Purkast.
People Testo, learned counsel for the petitioner with consent from the other side, price for listening the matter after
Item number 34 on 2nd of June, if possible.
2nd of June.
Yes, your lordship.
Okay.
Obliged.
May I please, your lordship, lordship beg to mention item number 3 and 4. We have taken consent of other side. Lordship, we need some time for filing reply in this matter.
Miss, your good name.
S.R. Majabuya.
S.R. Mazar Guya, learned counsel for the petitioner with consent from the other side, price for listening the matter after
Short date, lordship.
1 week. So as to enable her to file affidavit in reply. There, look.
Oblige.
May I please, your lordship. Lordship, I beg to mention item number 30. 30.
1330.
30. Lordship, I am praying for an adjournment for today.
Mr. Your good name.
S. Borhuya.
S.
Borhuya.
Barbuya,
Yes. On behalf of R. Mujumdar.
learned counsel
Petition.
for the petitioner with consent from the other side, price for listing the matter after
2 weeks.
2 weeks. There,
My lord, item number 40 of today's list, my lord.
40.
40.
Yes.
My lord, this matter may be adjourned, my lord. Please. My lord, the pleading is not completed in this case, my lord.
Leading.
Pleading is not completed in this case. I have to file affidavit in item number 40, my lord.
You are for the
Irrigation department.
education department.
Yes, your honor.
You inform the other side.
Now I will inform him. my lord.
No, you first inform the other side. Only then we will consider your fair.
Thank you. So, your honor, my lord, yes.
May I please, your lordship.
You are in item number
Item number 40.
No,
4041.
no, lordship. I want to make some mention, lordship.
Okay.
Item number 40.
Which matter?
Item number 40 damnation, আমি এইটো কাৰণে আছো।
May I please, your lordship. Lordship, yesterday, lordship, one bail petition was listed before this honorable court, lordship. I missed the matter, lordship. Lordship was pleased to fix this matter on 22nd. May I pray that lordship matter may be taken up on 19th, lordship. 4 accused persons were there, lordship. 3 has already been granted bail, lordship.
19th of
This month, lordship. It is fixed on 22nd, lordship. May I pray that lordship matter may be taken up on 19th.
payment method. No, কালে list আছে। No, I say non appearance.
Yesterday, it was listed as item number 29, lordship. I missed the matter, lordship. May I period that lordship, it may be
I
taken
cannot
upon
remember
19th
that.
or 20th lordship.
Okay.
Highly up.
Item number 14, customer time.
For admission, item one, Pathward Meter.
In this case, your lordship directed to file additional affidavit. Accordingly, we have filed yesterday, my lord.
One,
One.
no,
Lovely dress.
sorry. Basically, I have received the affidavit, my lord, but I want to file a reply, my lord. And there is an order, my lord, your lordship's order to produce the original list, select list, but probably that is not neither produced nor annexed.
Pardon?
Original list, that was your lordship's order,
Yes.
but that is not, I have not seen.
I have filed a.
Only photocopy I have seen in the lord. An order was your lordship to produce the original select list.
Select list was produced and your lordship was directed me to file an affidavit. So
But-
there is a, therefore this affidavit.
That was in a production
So
copy,
we
I have
can
seen.
record that actual select list.
No, no,
published by the-
Okay.
original
At the time
Excel,
of hearing, you produced the original one
yes, ma'am,
at the time of hearing.
At the
yes,
time.
ma'am, yes, yes. yes.
Lordship.
And in the meantime, I'll file me a
Okay.
reply, so that
Or
it may
Mr.
come.
Rosit, learned counsel for the petitioner, so PK, no, B Talukar, learned counsel for the respondents in elementary education department. Mr. Rosit, learned counsel for the petitioner submits that the respondent authorities have filed their affidavit in opposition and the petitioner will reply to the same. And he tries for listing the matter after
On 2nd or 3rd June, if your lordship.
second or third.
Third. Or 4th, any date I have not.
Third.
Well,
Parallel.
Your lordship, I for agenda number 5.
Mr. Reform for respondent number five.
possible.
Item number 2, Pathward Meter.
In this matter, my lord, I pray for some little accommodation, my lord. Last occasion, your lordship directed me to file affidavit, bring your record on certain instruction, my lord. Today morning, I have received a copy of the affidavit, my lord. Could not file, my lord. During the course of the day, I will file, my lord. So let the matter come on next Tuesday or Thursday, any day, my lord, next week, my lord.
Tuesday or Thursday. Okay. Tuesday. Third, Mr. S. U. Ahmed, learned counsel for the petitioner, and Mr. P. Talukar, learned standing counsel from the elementary education department, and Mr. Sharma. For respondent number 5, respondent number 5, AZ, and Madam
6.
Madam open for 6. Mr. Talukar, learned counsel, standing counsel for the elementary education department submits that he will be filing his affidavit in opposition during the course of the day. And he pays for fixing the matter on
On any date, my lord, next week, my lord.
20.
20, as a part heart.
This is a
Whatever.
Item 5.
May I please, your lordship? Lordship, kindly peruse the order dated 2/4/2025. Lordship. Second of April.
second of
April, Lordship. 2025.
yes,
Respondent side.
secondary education department.
Item number 5.
This is a third matter, possibly somebody else appeared.
You, Sharma,
You Sharma, I'll inform him.
he is present in the
He's
court.
there, he's there. He's in number 2.
Please inform me
Madam.
after some time.
Item 6, party matter.
May please, Lordship. Can you take up after some time, Lordship? Senior advocate Kian Chaudhary is coming, Lordship.
Lordship,
Just
here in the
put number
matter,
one.
Lordship, we will have to file an objection to the additional affidavit, Lordship, the rejoinder affidavit that they have filed. Because, Lordship, we have received on letter from the president of governing body that he has brought some documents which have been annexed in the rejoinder, Lordship, at point 5 of my instruction.
Lordship.
So, and the governing body has also lodged an FIR. So all these matters will have to be brought on record, Lordship. So I'll have to file a counter to that. Lordship, at point 5 of my instruction, Lordship.
Lordship, last occasion already hearing concluded, my senior
Lordship, this
already
is-
argued the matter, Lordship. After 12 days, the matter was listed, Lordship. There earlier they said that there is no record in their affidavit, Lordship.
Lordship,
Lordship,
at point number 5.
kindly take up after some time, Lordship. My senior may be come.
Anyway, Lordship, we will have to file our counter to that rejoinder affidavit. No to file.
Because we are not concerned with the president, Lordship, managing committee president. We have challenged the government order, suspension order, Lordship. There is some inquiry and repeated suspension is there, Lordship. There is no concern with the president, Lordship. President is the college functioning, Lordship.
But
There
that-
earlier-
but that doesn't allow him to annex forged document in a court of law. So, Lordship, we'll have to bring this on record, Lordship.
No, let Mr. Chaudhary come
Yes.
after
Okay.
some time.
Yes. Lordship. Obliged.
Item number 8,
Please, Lordship. Concerned council CCC, access wise like some other two pieces. Kindly pass over the matter for them.
okay. Item 9,
Lordship, similar player, Lordship, Mr. R. Mazumdar is appearing in both this matter 8 and 9. May I play this matter?
item 10, item 10,
None appears for the petitioner on call, is the matter of the 2 weeks.
item 10.
Item 10. May I please, Lordship?
Okay.
As per instruction, headmaster already submit the pension letter
Pardon?
to IS of Bangladesh. As per instruction, headmaster submit already pension letter.
She says that as per her instruction, Malad, the pension paper has already been submitted to the inspector of schools. I'll take an instruction. I'll verify, Malad.
Okay. Third miss,
She does.
she does learned counsel for the petitioner and Mr. Kaushik, learned standing counsel for the
Secondary education.
secondary education department. The learned counsel for the petitioner submits that the petitioner has already submitted the pension papers with
To the IS of
inspector of
Bangladesh.
the inspector of school. Who is district?
Bangladesh.
Boy.
Bongaigaon. Bongaigaon. Mr. Kaushik learned standing counsel to the secondary education department submits that he may be granted some time to obtain necessary instruction. There is a lot versus a less than a matter of the 1 week.
Obliged.
Item 11,
Lordship, Lordship, I have received an instruction on 13/5. The inspector was also forwarded to the director of pension. The pension proposal,
13/5.
13/5/2020.
Later on, Mr. Kaushik apprised his court that the inspector of the school has forwarded the pension papers to the directorate of pension on
13/5/2025.
13/5/2025. Who is co-director of pension?
Pension.
Ms. Kokon, learned standing counsel for the Directorate of Pension. Shall obtain necessary instruction as to the up-to-date status of the pension paper submitted by the petitioner on next day. Please the matter after 2 weeks.
Your lordship, we have not received the application copy, your lordship.
Furnish it, a copy to
Lead petition she will furnish. I'll furnish the instruction.
Our name is not being shown. Finally, our name may be shown in
The name of standing counsel for the Directorate of Pension shall be reflected in the clause list next day.
Item 12.
11.
This was 10.
This was 10.
Lordship, in this matter, yesterday we have filed a affidavit in opposition, but there was an order of this court to get the records, Lordship. So that records are not yet available, Lordship. Can this matter be taken up after 10 days, Lordship? In the meantime, I'll get the records.
Date may be fixed, Lordship. This matter
Yes.
is pending for a long period of time.
Okay. Third, Mr. S.P. Sodhuri, learned counsel for the petitioner, and Mr. D. Tomino for respondent in higher education
No,
department.
Lordship, it is medical education and research department.
Medical education.
Medical education and research department.
Medical education and research department, and Mr. Bhagavati for
He's not there, Lordship.
Lordship, I am only for the respondents, for all the respondents.
all the respondents.
One to five.
You are for? Respondent. number-
Principal Secretary.
Your good name, please.
This is 11, Lordship. I am appearing for all.
For all.
Please for item 12, Lordship.
For
11.
Okay, Mr. Upamanu submits that the original records are not available with him. And he pays for granting him some time to produce the original records. There is allowed, this is a less than after 1 week.
1 week, date may be fixed,
10
Lordship.
days, Lordship. Because yesterday, Lordship, I have filed my affidavit also, Lordship. That is also not on record, Lordship. They might also want to file a reply.
A date may be fixed in the first week of June.
28.
28, 5. Obliged, Lordship.
Highly.
Item 12.
Lordship, this matter may be fixed before the appropriate bench. As per order dated 8 January 2025, all cases relating to service matters of staffs of Guwahati High Court and subordinate courts were to be listed before the.
Well, what has happened, madam, this is pertains to the election, madam, to the post of peon in district and session judge Kamrup. Now there is a notification that all the matters relating to Guwahati High Court, madam, will be listed before Justice.
Mr.
De-
Debashish Borua.
Justice Borua, madam. So that this matter will have to be listed before that bench, madam. So I pray that date may be fixed and let matter may be listed before that bench.
Okay, recessal is the matter before appropriate bench on
On next week, madam, in date? On
Next week.
Thursday, madam?
No, that notification relates to the employees of the Guwahati High Court.
No, all matters, madam, those are been where the standing counsel
Staff,
of High Court appears, madam, that will go to.
Matters
the-
pertaining to the staff of Guwahati High Court and services relating to the.
Okay, subordinate court also.
Also.
Okay.
The date may be fixed, madam, madam.
Registry will fix the date.
Madam, can it be on 22nd, madam? 22nd.
Let the matter go before the appropriate court. Let the matter go before the appropriate court.
Yes. I'm praying for a date, madam. 22.
Item 13.
22.
May it please your lordship, the matter relates to compensation and appointment, lordship. The matter is covered by this judgment, lordship, of this honorable court, lordship. It is a covered matter, lordship, because the case was pending. Kindly peruse paragraph number 9, lordship.
Three years left.
3 years left. 3 years left, no, 3 years left, no, compensation and appointment, right? Michael Dutan কমাই দিছিলে। আপোনাৰ মেটাৰটো তিনি বছৰটো আছে, ঠিক আছে? পেণ্ডিং আছিলে যেতিয়া অৰ্ডাৰটো পাছ হৈছিলে। Lordship, I have produced the judgment, lordship, before your lordship. A judgment. WPC 342 of 2015 Lordship, recent judgment Lordship.
Yes, any objection from the?
Lordship,
respondent side?
as per the paragraphs 10, Lordship, it may be disposed of, Lordship.
Lordship,
Okay, well,
Lordship.
Lordship. Oblige your Lordship.
Item 14.
May I please, your Lordship? My lord, this matter is also compassionate appointment and covered by judgment 342/2005, my lord. Matter is pending before DLC, my lord. Long back from 7/3/2022, my lord.
As per our affidavit, Lordship, DLC has not been considered, Lordship. He has stated that SLC not considered, Lordship. As per our instruction and our affidavit, it says that DLC is not considered. They are
Lord,
named,
can I-
Lordship.
My lord, may kindly see the annexure 3, my lord. Anyway, my lord, matter is pending before DLC, whether they reject it or allow it, my lord, send it to DLC or they reject the matter.
Otherwise, I have no problem.
So on.
DLC
the
may
basis-
consider
That judgment,
my case.
on the basis of that judgment, we will dispose of the matter.
Yes, my lord.
Any objection?
No, Lordship. Only my submission is, Lordship, kindly, it should be in para 10, Lordship. The judgment of this honorable court, Lordship, it should be para 10, Lordship.
Okay. Okay.
Oblige your lordship.
May I please report? My lord, the petitioner, before your lordship, has been working since 2005 to till date. My lord, but his service neither been regularized nor he has been given the, my lord, benefit of minimum pay scale. So this, my lord, writ petition. Now lordship kindly see first at page 66, the earlier round of litigation, the order passed by this novel court at page 66, my lord. Item 15. Page 66.
Yes.
Yes. Now, authority part, my lord, page 67. From, my lord, para 3, my lord. May I read, my lord? Page 67.
Yes.
Para 3, my lord. The petitioner is an MPhil by qualification and was appointed as lecturer in the Department of English in the Hapragat Mahavidyalaya in Golpura district on 27/2005 as per the resolution of the governing body of the college dated 18/5/2005. The appointment order of the petitioner provides that it is on a contractual basis, but the fact remains that the petitioner is continuing to serve as such till date. It is also stated that the petitioner is working against the sanctioned post in Havraghat Mahavidyalaya, but because of initial nature of his appointment, which is stated to be a contractual appointment, the petitioner had not been regularized in his service. Over the passage of time, the petitioner is disadvantaged to an extent that although the time of his initial appointment, he had all the required qualification for the post of lecturer in English, but in the meantime, due to the subsequent changes in the required qualification, he may not be eligible for a direct recruitment, and the petitioner as well as also is at about 46 years as of now. Considering both the aspects, the only option remained for the petitioner would be regularized in his service. The petitioner may have been appointed on a contractual basis initially, but a contractual appointment is always understood to be for a given period of time, as time is always essence of a contract. The continuation of the more than 14 years till date do not indicate there is an essence of time in engagement of the petitioner. Be that as it may be, the petitioner is stated to be working against a sanctioned vacant post, and he had served more than 14 years. Even if we go by the spirit of the law laid down by the Supreme Court in the Secretary Estate of Karnataka versus Uma Devi and others reported in 2006 for SCC 1, a legal right has accrued to the petitioner for being considered to be regularized in this service. In this circumstance, the petitioner, apart from his earlier representations, had also submitted a representation dated 16/1/2020 before the Director of Higher Education Assam, claiming regulation in its service. We are of the view that the factual circumstances in which the petitioner was appointed and is serving as a lecturer, again, assistant professor in English in Habragarh Mahavidyalaya, a legal right has accrued in favor of the petitioner for an appropriate consideration by the Director of Higher Education towards his claim for regulation as indicated above. In view of the above, interest of the justice will meet on a direction to the Director of Education to consider the representation dated so and so and pass a reason order thereof. Although paragraph 53 of the Secretary, State of Karnataka versus Uma Devi Supra as submitted by Mr. So and so may not be applicable, but we are of the view that at least the spirit of the said judgment is required to be given a consideration. A question would arise that if the petitioner was appointed against a sanctioned vacant post and due procedure was followed at the time of his appointment, whether the appointment can still be considered to be an appointment on a contractual basis instead of regular appointment, even after 16 years of being appointed. The reason order to be passed within a period of 2 months from the date of the receipt of the certified copy of this order. Now, after this, my lord, lordship will find the order, director passed the order, my lord, that the lordship will find at page 80. Page 80, my lord. May I read, my lord? Speaking order dated 18/7/2022. Read the honorable.
By this order, your prayer has been rejected.
Rejected, my lord. Then, my lord, he filed an appeal before the, my lord, appellate authority, and appellate authority also, my lord, rejected that your lordship will find at page 113. Page 113, my lord.
Yes.
Yes. This is, my lord, may I read the, my lord, relevant portion, my lord. Para 2, my lord, dated 5th of October 2023. The petitioner Rafiqul Islam is serving as a lecturer in a non-sanctioned post in the Department of English in Habragarh Mahavidyalaya on contractual basis and has paid for regularization provincialization of his service on a ground of his long tenure. However, as per the Assam College Provincialization Act 2005 and the Assam College Provincialization Rules 2010, there is no provision for adjustment regularization of the lecturer who are working against non-sanctioned post, and the college teachers in the provincialized colleges shall be filled up by direct recruitment by following the selection process. Moreover, the petitioner Rafiqul Islam is also not within the specific category of teacher whose grievances were addressed by memo number so and so dated 17/7/2024, as his name was not included in the final seniority list. The said OMO was a one-time measure to address the grievance of the specific group of lecturers. The said OM was purpose specific, and once the objective of the OM was achieved, another OM dated so and so was issued stipulating no college under the deficit GIA system should engage any person as lecturer where no sanctioned post exists. The OM number so and so was not intended to be a fundamental source of regularizing the service of the lecturer, and as such the petitioner case cannot be considered for regularization adjustment. In view of the above, this is the order.
So you are surrendering this order.
This order. And lordship kindly see in this writ petition, our limited period, lordship kindly see at page 24. Page 24. Page 24, my lord.
Yes.
Yes. Now here, my lordship kindly see the impugn order dated 5/10/2023. Lordship has seen. Now, second para, my lord, issued by the respondent, direct the respondent authorities to pay minimum of the pay scale to the petitioner as in the light of the spirit of the decision of the Honorable Supreme Court in the State of Punjab versus Jagjit Singh, 2017 on SCC, and the decision of the Honorable High Court reported in Upen Das, so and so. It there. আরো কবি আছে না, আরো কবি আছে। এটা বুঝতে পারলেন না?
No, Mr. Mandala, whether this decision in the case of State of Punjab versus Jagjit Singh will applicable in the case of police research?
Now, in all other cases, as held by the Honorable Apex Court, in all other cases. Okay.
But as per this impugned order, there is no provision in the act for such regularization.
Now, Malata, under the Act 2005 and 2000 Rule 2010, there is no provision. But his appointment was made in the year 2005 under the Malata 1776 rules. It is not that Malata, his appointment is made under the 2005 Act. He was appointed in the year 2005 itself. So the rule was governing in that particular time was 1976 rules.
Whether there was any provision in that rule for regularization?
Yes, there was a provision. That is, the earlier rule was Assam Aided College Management Rules 1976. The Assam Aided College Management Rules 1976.
Nineteen
76. Their lordship will find Rule 18 first.
eighteen
18.
18.
Then, my lord, Rule 19, Sub-Rule 4, Roman 4.
Page number?
Page number, my lord, 433 in my book, my lord, the green book. Rule 19, Roman 4. Rule 19 says, my lord, the following particulars duties are assigned to the governing body. Roman 4 lordship will find to appoint person in connection with the affairs of the college as per provision of the rules in force. Lordship body. Then lordship kindly see the rules 1960. Page 448. The Assam Aided College Employees Rules 1960. Their lordship will find Rule 4 first. Rule 4, Roman 3, my lord. That is page, my lord, 450. Page 450, my lord. Lordship body. Rule 4, Roman 3.
Yes.
Yes. Then lordship will find page 451, Rule 4. Again, my lord. 4 within bracket 4, my lord. Power to fill up temporary vacancies. Page 451. except where it is otherwise provided in these rules, the governing body shall have powers to fill up any temporary vacancy without advertisement, which may not extend beyond 6 months, subject to necessary approval of the Director of Public Instruction, Assam. Now, Rule 5, Lordship will find page 452. There, my lord, 5, Roman 2, Lordship will find. Five Roman 2, my lord, a professor or lecturer, a candidate shall hold at least a second class master degree in subject concerned. That is regarding qualification.
Yes.
Yes. Now, for a time being, my lord, Lordship kindly see, Lordship has already seen page 450, last 3 lines. 450, last 3 lines. Appointment of professors or lecturers already in service shall be entitled to regularization of their services only when they fulfill the condition as laid down in Rule 5.2.
Yes.
Yes. Yes. Now, my lord, I have submitted the, my lord, judgment in, my lord, State of Punjab versus Jagdish Singh. The Lordship will find particularly, my lord, paragraph 42, 60, 61 and 5, my lord.
What is that judgment?
Yes. Yes. Now,
Page
first,
number?
Lordship, yes, first Lordship kindly see, my lord, para 5, my lord. Para 5. May I read, my lord? Para 5, my lord. The issue which arises for our consideration is whether temporarily engaged employees, daily wages employees, ad hoc employees, appointment on contract, casual basis, contractual employees, and like are entitled minimum of regular pay scale along with the dearness allowance as revised from time to time on account of their performing the same duties which are discharged by those engaged on regular basis against sanctioned post. The full bench of so and so, while adjudicating the upon the above controversy, had concluded that such like temporary employees are not entitled to the minimum of the regular pay scale merely on reason that the activities carried on by daily wages and regular employees are similar. However, it carved out 2 exceptions and extended to the minimum of the regular pay to such employees. The exceptions recorded by the full bench of the High Court in impugned judgment are extracted here in below. Or that is the judgment referred, my lord, extracted below. Now, Lordship kindly see para 42.
Yes.
Lord, 42, my lord, in a moderately, my lord, discussed by the apex court. It is a long paragraph, my lord. Now, Lordship kindly see last paragraph 42. My lord, 42.14, my lord. Para 42.14.
Yes.
For parity in any scales under the principle of equal pay for equal work, equation in the nature of the duties is on the paramount importance. If the principal nature of the duties of one post is teaching, whereas that of the other is the non-teaching, the principle would not be applicable. If the dominant nature of the duties of one post is of the control and management, whereas the subject post has no such duties, the principle would not be applicable. Likewise, if the central nature of the duties of the post is of the equality control, whereas the subject post has union duties of the quality control, the principle would not be applicable. Then, my lord, para 42.16. Then finally, Lordship kindly see, my lord, para 61. That is the, my lord, outcome of the, my lord, husband, my lord. Para 61, Lordship will find. Page 224.
Yes.
In view of the position expressed by us in the foregoing paragraph, we have no hesitation in holding that all the temporary employees concerned in the present bunch of cases would be entitled to draw wages at the minimum of pay scale at the lowest grade in the regular pay scale extended to regular employees holding the same post. Now, being a lecturer, he used to take classes of the Malad students, and Malad, he used to Malad serve as an invigilator also of the colleges. Open to the. Yes, open. Arota governance. Open. Paragraph.
I have not seen.
Yes.
Yes, your part is over.
Yes. On more judgment, Malad. Yeah. Now, Malad, recent judgment Lordship will find Jaggu versus Union of India. Yeah.
Nature of work is 10:30. Paragraph 10. The nature of work is 10, paragraph 10.
Their Lordship will find Malad first paragraph 10, Malad. Paragraph 10, Malad. Having given careful consideration to the submission advance and the materials on record, we find that the appellant's long and uninterrupted service for periods extending well beyond 10 years cannot be brushed aside merely by labeling their initial appointment as a part-time or contractual. The essence of their employment must be considered in the light of the sustained contribution, the integral nature and their work, and the fact that no evidence suggests their entry was through an illegal and superstitious route.
If the post is sanctioned and fundamental in the perennial post, then.
Now, then, Malad, page, Malad, para 27. Para 27, my lord.
Yes.
Yes. In the light of this consideration, in our opinion, it is imperative for the government department to lead by example in providing a fair and stable employment, engaging a workers on a temporary basis for extended periods, especially when there is rules are integral to the organizational function and not only the contravene to international labor standards, but also expose the organization to legal challenges and undermine the employees' morale. By ensuring the fair employment practices, government institution can reduce the burden of the unnecessary litigation, promote job security, and uphold the principle of justice and fairness that they are meant to embody. This approach aligns with the international standard and set a positive precedent for the private sector to follow, thereby contributing the overall betterment of the labor practices in the country.
Interpretation of Umadevi.
Yes.
Paragraph 20.
Now, one more important paragraph, my lord, lordship here will find
Interpretation of Umadevi.
para 20, my lord. The decision of the Umadevi has been, my lord, interpreted in a elaborate manner, my lord. Para 20. Para 20, my lord.
Yes.
Yes. It is well established that the decision of the Umadevi Supra does not intend to penalize the employees who have rendered long years of service, fulfilling their ongoing necessary functions of the estate or its instrumentalities. The said judgment ought to have prevent backdoor entries and illegal appointments that incumbent constitutional requirements. However, where appointments are not illegal, our appointment is not illegal, it is at best irregular, but possibly irregular, where employees had served continuously against the backdrop of the sanctioned functions for a considerable period, the need for a fair and human resolution becomes paramount. Prolonged, continuous, and unblemished service performing tasks internally require a regular basis can, over the time, be transformed what was initially ad hoc temporarily into a scenario demanding their regularization. In recent judgment of the Supreme Court, Vinod so-and-so, it was held that the procedural formalities cannot be used to deny the regulation of the service to an employee whose appointment was termed temporary, but has performed the same duties as performed by the regular employees over a considerable period in the capacity of the regular employee. The relevant part of the judgment have been reproduced. Now, in our case, my lord, this gentleman has been serving last 20 years continuously. This gentleman has been serving last 20 years continuously, my lord. Yes. Now, finally, my lord, lordship will find para 28. Para 28.
Yes.
In view of the above discussion and findings, the appeals are allowed, the impugned orders passed by the High Court and the Tribunal are set aside, and original application is allowed to the following extent. The termination order dated so-and-so are quashed. The appellants shall be taken back on duty forthwith and their services regularized forthwith. However, the appellants shall not be entitled to any pecuniary benefits, bag wages for the period they have not worked for, but would be entitled to continuity of service for the said period, and the same would be counted for their post-retail benefits. That is the matter.
Who is appearing for the respondents? Yes.
So in this case, earlier present petitioner approached the already he has stated lawsuit. Accordingly, the director issued a spring order, regional spring order lawsuit. And against the spring order lawsuit, he has preferred an appeal, the appeal was also rejected by the authority. Against that, he has approached before his marriage. So before that, we have go the background of this case lawsuit. Basically, petitioner seeking regulation lawsuit and adjustment lawsuit. Although he was working as a lawsuit, as a part-time lecturer, lawsuit may kindly peruse the appointment order lawsuit. It is in page 27 lawsuit. It was issued on 15/7/2005 lawsuit by the principal of Habraghat Mahavidyalaya Krishna lawsuit. The content is that lawsuit as per the resolution norm 9 of the governing body meeting held on so and so was appointed in economics are hereby allowed to take up classes. My lord may kindly mark it as a tutors in English and economics respectively lawsuit. In both the subject, he was appointed as a tutor lawsuit. English and economics respectively with lump sum remuneration of so and so purely on not need basis and part-time basis lawsuit. He was appointed as a tutor in a 2 subject course. In the Department of English and Economics lawsuit. As a need basis lawsuit, as and when required, with a remuneration of so and so lawsuit. There is no advertisement, no formal appointment of the petitioner. Even we see that two law which was referred by the petitioner is totally misplaced in this case. This is not applicable lawsuit. The governing law is lawsuit 2005 Act and 2010 rules. I will come to lawsuit. The law which was the act which was referred by the petitioner lawsuit, he says that he is governed by that Assam Aided College Management Rules 1976. This is totally misplaced lawsuit. Provision itself says, my lord may kindly peruse 430, page 430 law. One section I will refer lawsuit, section 14 lawsuit. At the relevant point of time, when the college was in the grants in age system lawsuit. 14, occurrence of any vacancy in a governing body shall be reported to the secretary of the governing body, forthwith the director of public instruction who shall take steps to fill up the vacancy in the manner in which it was originally filled up lawsuit. Director of public instruction means today lawsuit the director of higher education. This is the procedure lawsuit. When there is any vacancy arose in a particular college's lawsuit, at that relevant point of time, when the college was in the grants in age system of college, it is the duty of the governing body to inform the secretary of the governing body. Secretary means that at the relevant point of time, principal itself is the secretary. He has the duty to lawsuit, forthwith inform the lawsuit, director of public instructions. Now that is the director of higher education. And accordingly, higher education, director of higher education has filled up the post as per the procedure lawsuit. Then my lord may kindly come to next rules lawsuit 1960 rules lawsuit.
Page number.
Page lawsuit 448 starts from 448. When the colleges are in the grants in aid system lawsuit, there 2 rules are follows lawsuit. Method of recruitment is 449 lawsuit. 449. Principals, within bracket professors and lecturers lawsuit. There shall be a state board consisting of the following so and so. I will not grant further lawsuit. There shall be a state board for selection of principals, lecturers, and professors lawsuit. And due advertisement should be there. That is whole procedure. I will not go through it. Even for temporary appointment, that is also lawsuit may kindly peruse 451 lawsuit. The governing body concerned may, after due advertisement, fill up any vacancies for a period not exceeding 3 months, subject to prior approval of the director of public instruction assignments. If lawsuit temporary appointment also done lawsuit, it's as like as TF lawsuit. Then also it should be by way of advertisement
and the prior approval of the DPR should be lordship there also. Even lordship 4 also says that power to fill up temporary vacancies, except where it is otherwise provided in this rule, governing bodies shall have powers to fill up any temporary vacancy without advertisement, which may not extend beyond the 6 months, subject to necessary approval of the Director of Public Instruction. This is the statutory prescription prescribed by the statute lordship. In petitioner's case, lordship, not a single statutory prescription prescribed by the statute was followed lordship. Although that particular tool, act and rules is not applicable in this case, lordship, even suppose for a moment, lordship says hold that particular act and rules is applicable, then also lordship, the statutory prescription prescribed by the statute is not followed here. And lordship, the colleges which were in the grants in age system, lordship, that was taken by the government lordship as a full-fledged colleges, lordship, provincialized colleges under 2005 Act lordship. 5 Act is lordship in page 491 lordship.
Yes.
It's Assam College Employees Provincialization Act lordship, 2005. And definition clauses, colleges lordship 2A means a non-government college in Assam in respect of deficit grants it from government and imparting general education of arts, commerce and science stream those in the graduate level lordship. And employees means an employee of the college, both teaching and non-teaching appointed substantively against the sanctioned post lordship. And employees to be provincialized lordship, it is in section 3 lordship. In section 6 is the lordship, selection and appointment of the employees lordship. It is the next page 493 lordship. When the colleges are in the grants in age system of college, as per the policy decision of the government, that act was also enacted, and accordingly the colleges which were in the grants in age system, they are under this act lordship. Come within this act, there is a statutory prescription is also there lordship. Who wants to, the employee lordship who wants to be the whole act, then lordship there is a procedure. It is in Rule 8 lordship, mode of pension and others lordship. And 6 is the lordship, selection and appointment procedure of the employee. It's by way of a direct recruitment lordship. Appointments of both teaching and non-teaching posts in the colleges shall be made by the Director of Higher Education Assam on the basis of selection and recommendation of the governing body of the respective colleges in accordance with the rules and procedure government in force lordship. And then 8 is there lordship. Just I give the background lordship. 8 is there, mode of pension lordship. The existing employee, there is a lordship, CPF provision is there. Contributory Provident Fund provision is there. If the employee wants that lordship, he can retain this. And if employee wants that after the provincialization, he should come under the pension scheme, then he have to return the lordship, the government share, then he will get the regular pension. This is the procedure is there lordship. Then lordship, 12 is the rule making power. And accordingly, on the basis of that, 309 rule was prepared in next page lordship, 496. 496 is the procedure. That 5 is the lordship recruitment method lordship, method of recruitment. And 5.2 is applicable here lordship as a post of lecturer. Then lordship 7 is the lordship direct recruitment. And 5.7 lordship, 5 subsection as sub rule 7 lordship in all next page lordship 498.
Yes.
In all these cases, the governing body shall conduct the selection process and recommend it to the director who shall issue the order of appointment lordship. Then lordship the direct recruitment 7. And my lord, not a single provision is there in the act and rules Even 1971 when college was granted system of college also, and 1963 rules also, Lordship, 2005 rules act also, 2010 rules also. There is a not a single prescription is there regarding Lordship, regulation and adjustment, Lordship. There is no concept for regulation and adjustment. All are direct recruitment. And these particular issues, Lordship, which petitioners is claimed, Lordship, already settled by this honorable our High Court. Several judgment, one full bench judgment is there, several division bench judgment is there, more than Lordship, 50 single bench judgment is there. I will refer only 1 and 2 judgment, Lordship. That's because the Lordship, at the time of the deficit grants in each system of college, Lordship, college were engages lecturers, Lordship, on the need basis. So after coming into force of the 2005 Act, Lordship, there is no provisions for, Lordship, regulation. As such, some of the petitioners approached before this honorable court, Lordship. And government had taken a policy decision, it is 17/7/2004 policy decision is there, Lordship, to adjust a particular group of employees who were appointed against the non-sanctioned post, Lordship. Even the petitioner is not in the category of non-sanctioned also, Lordship. In the non-sanctioned post, 300 odd numbers of teachers were, Lordship, has say list was prepared, and that list was as per our High Court judgment, Lordship. Honorable High Court directed the government to prepare the teachers on the basis of the seniority who are engaged in a non-sanctioned post, Lordship, and take a one-time decision to adjust their services in the existing vacancies, Lordship. And accordingly, government has a policy decision 17/7 OM was, Lordship, prepared. On the basis of that, Lordship, after the direction of the honorable court, Lordship, 326 seniority basis list was prepared, and that was published in the Assam Tribune newspaper in 2010, Lordship, and seeking some clarifications and objections from the candidates as well as other concerned, Lordship. Accordingly, a final list was prepared, 356 numbers, Lordship, and that list was approved by our High Court in a full bench decision, Lordship. Our High Court direction is that, Lordship, the persons who were appointed prior to 17/7/2004, they are eligible for consideration for adjustment under the one-time exercise taken by the government, Lordship. This is the view taken by the full bench, Lordship. And the matter came before the full bench. There is a two conflicting judgment is there. Just I repeated. After that, I will hand over the judgment, Lordship. One judgment says that, Lordship, the persons who were appointed prior to 17/7/2004, Lordship, they should be adjusted as per that particular OM, Lordship. And after that, another division bench judgment is come, Lordship, and comes. One Samsu Haq is there, Lordship. His appointment was made, Lordship, prior to 17/7/2004, Lordship. But he joined the service after 17/7/2004. Accordingly, Honorable Division Bench says that as because his appointment was done prior to 17/7/2004, although he has joined after the 17/7/2004, his case is within the considered zone of 17/7/2004. And accordingly, this matter was the two conflicting views was there. This matter was referred before the Honorable larger bench, Lordship. Larger bench opined that, Lordship, the persons who were appointed prior to 17/7/2004 and who were joined, they are to be adjusted, Lordship. Accordingly, that view was taken, and that was reiterated after the several division bench judgment. Lastly, in, Lordship, Abdul Wahid judgment. Abdul Wahid judgment, Honorable Division Bench says that the persons whose names were reflected in the seniority list, they are to be adjusted. Even the persons who were appointed prior to 17/7/2004, but their names is not reflected in the seniority list prepared by the government on the basis of the direction given by the High Court, Lordship, that persons also not in the considered zone, Lordship. And admittedly, Lordship, petitioner was appointed in, Lordship, 15/7/2005 lordship, after 17/7/2004, and his appointment was as a tutor, even not a contact, not against that lordship, non-sanctioned post also lordship. So lordship, I just referred division bench judgment lordship, where the full bench judgment was also discussed lordship. Before that lordship, one OM I will hand over lordship, one OM lordship, that will be clear lordship. After lordship, the 17/7/2004 OM was issued lordship, then another OM was come on 12/10/2004 lordship, where there is a direction to the authority not to engage lordship any persons lordship. Prohibition for engagement of teaching and non-teaching staff in deficit grants in 8 colleges without any sanction post lordship. 2, 3, 4 in there lordship, I will not reiterate it lordship. That by violating this OM also, he was lordship engaged as a tutor lordship. That person was not appointed by us, it is a temporary engagement by the college authority. We are not responsible for that engagement lordship.
Yes.
Yeah, 2018 5 GLT 80, it's a division bench judgment, here full bench also referred, I will hand over a copy of the full bench lordship. Full bench copy to answer. So lordship, I am referring paragraph 6, 7, 8 and 9 lordship. Lordship, I can read it lordship.
No, not necessary.
6 in respect of lordship, that particular OM. 7 in respect of the full bench decision. And accordingly, ultimate finding is that other paragraphs lordship. In this case, just synopsis I will read. In this case, the particular petitioner was appointed in the Kharpeta College prior to 17/7/2004 in a non-sanctioned post. Not as a tutor, he was appointed a non-sanctioned post lordship. So before 17/7/2004. But his name was not reflected in the lordship, the seniority list, which was prepared as per the Honorable Court's direction lordship. That's why the findings of the Honorable Court is that although he is appointed prior to 17/7/2004, as because he was not in the considered zone of the specific targeted group, so his service cannot be regularized or adjusted. This is the view. And it was reiterated in several single bench judgment. I just hand over 1 and 2 judgment.
Not necessary.
That judgment whole thing is reflected, only one judgment I will refer.
No.
Lo-
The
loss-
law is settled by the division
Loss-
bench,
loss.
why single bench is required?
Lordship. Full bench judgment also I will hand over copy lordship. So lordship, our case is that our speaking order itself is very specific lordship, that page 88 lordship. The whole page 80 lordship. Page 80 lordship, everything is here lordship, I will not reiterate it. Page 80 lordship, it's a well-vision order passed by the authority lordship. Even lordship, our High Court full bench judgment, division bench judgment, single bench judgment was also quoted here lordship.
Okay. So your part is over.
And one judgment was referred, Jogo's case is not applicable here. In that particular state, there is no specific rules and regulation lordship. Here we have the specific rules and regulation governing the field lordship. And that persons were engaged against the sanction post and long-term lordship. And that here this particular person is lordship is at inquiry basis is a tutor lordship. And that equal pay for equal work judgment also lordship he should be continuously serviced in a particular period, Lordship, against the sanction post, Lordship. And here that particular person was not engaged by the government, Lordship. Full bench judgment, thus I am the purpose. On the basis of the debt full bench judgment, other judgment is Lordship. So that's why full bench judgment I am the Lordship. And that Jogos case, that particular persons were appointed by the department itself. It is not applicable, totally misplaced. Here, the law is well settled by our High Court in a full bench judgment, division bench judgment, various single bench judgment. So, I will not reiterate it. Under the above factual circumstances, petitioner case is not within the considered term. It is a well settled principle of the law. Even Lordship, hundreds of other more than 50 persons opposed before this honorable court. I have all the single bench judgment, Lordship. Then Lordship, another honorable Supreme Court judgment is there, Lordship. Which was authored by Minor Justice Bela Trivedi, Lordship. It says that equal pay for equal is not a fundamental right vested to an employee, though it is a constitutional right achieved by the government, Lordship. Here it says that even Lordship the work is similar, then also he is not entitled for equal pay for equal work. If qualification is not there, service condition is different, that is there also. And I will end the right, Lordship.
Yes, Mandala, what is your submission in respect of this OM dated 12th of October 2004? You have the copy with you?
My lord, that OM, my lord.
Yes.
Yes. My lord, that OM is not applicable to us because this gentleman has been appointed after that OM, my lord. After that OM, Lordship, kindly see at page 28.
After the prohibition OM issued by the government, Lordship.
Do you have any extra copy?
OM, I have only hand over.
No. What is the copy to him? He may not have it.
Even also required 77 to 2005, I can also hand over.
Oh, yes, pardon.
12th October. My lord, this is, my lord, office memorandum. This office memorandum, my lord, cannot supersede the statutory provision of the, my lord, rules.
This is our case.
Lordship has already seen the 1976 rules and 1966 rules. Those rules permits the governing body to appoint a lecturers. Now, this is the OM. It cannot supersede the statutory rules. Now, in this context, my lord, there is a cut-off decision of the apex court. The OM cannot supersede the statutory rules and the provision of the Act. Now, Lordship, kindly for a moment, my lord, page 28, Lordship, kindly see. Page 28 of our petition. Page 28. It is dated, my lord, 15/6/2005. Page 28. (15/7/2005). Then another engagement letter, Lordship will find at page 31. Page 31, that has been, my lord, reiterated elaborately, my lord. May I read, my lord? Page 31. In continuation to the resolution number 9 of the governing body meeting held on 18/5/2005, as well as the letter number so and so dated so and so, regarding the part-time lecturer in the Department of English, and also letter issued number head of the Department English so and so dated 30/1/2006 to the undersigned requesting for the need-based appointment in the Department of English. I am for the English, my lord. Sri Rafiqul Islam, so and so, and another similar that is different, my lord, are hereby appointed temporarily as part-time lecturer in the Department of English at a lump sum remuneration of rupees 400 rupees per month, one need base for the smooth function of the departmental activities subject to the approval of the governing body. It is worth mentioning that the Sri Rafiqul Islam and so, I am not concerned about second person, my lord, have extended their valuable service to the department and the college from the middle of 2005 to the December 2005. At present, there is only one permanent lecturer in the Department of English, though there has been a major course. Therefore, this temporary arrangement for the appointment of the part-time lecturer on need base becomes necessary for the greater interest of the college as well as the department. Their services may be regularized afterwards as a non-sanctioned post through the proper process with the due approval of the governing body. That is the, my lord, stand of the governing body. Now, lordship, kindly see for a moment, my lord, my friend has referred the provision of the act and the rules at page, my lord, 490, lordship, kindly see. Page 490.
Yes.
Page 490, my lord, Act 2005. Lordship will find, my lord, in the down below, my lord, published in the Assam Gazette Extraordinary Number so and so dated 23rd December 2005. 23rd December 5. And this gentleman was appointed on 15/7/2005. So how can this act and the rules subsequently, lordship, kindly see the, my lord, rules that has been referred my friend at page 496. Rules 2010 496. Page 496. Lordship will find in the bottom, my lord, published on extraordinary 22nd November 2010. So much later to the appointment of the petitioner, my lord. So, my lord, the petitioner case is governed by the 1976 rules and 1960 rules.
And 1967 and
My lord, we have already, my lord, given 1976 rules and, my lord, 1960 rules. That is, my lord, the Assam Aided College Management Rules 1976 and Assam Aided College Employees Rules 1960. Those two rules we have already. Now, my lord, one further point, my lord, we like to, my lord, draw your lordship's attention how it was, my lord, injustice was done to the petitioner. That will be revealed from the, my lord, one point, my lord, I am referring, my lord. Lordship, kindly see for a moment, my lord, page 40 of my writ petition, my lord. Page 40. Now, an attempt was made to regularize the service of the petitioner as a lecturer, and accordingly, my lord, an advertisement was issued and interview was held that your lordship will find at page, my lord, 40. Lordship, kindly see the petitioner's name, my lord, at serial number, my lord, 21, page 40. Lordship got it, my lord. That was the interview. And ultimately, my lord, there is a, my lord, comparative statement of marks. Lordship will find at page 47. Page 47. Serial number 21. There, my lord, lordship will find the petitioner, we have calculated the mark the petitioner got the third position. And first position and second position, they did not turn up. Since the first position and second position did not turn up, ultimately the petitioner's number would have been for consideration for regularization. But suddenly, the authority has cancelled that particular interview, taking the plea that there was anomalies in the grading of the marks that your lordship will find at page 53. Page 53, my lord. Page 53, lordship got it. Now lordship will find the dated 17/5/2013, the copy of the resolution number so and so, Mahavidyalaya meeting held on 17/11/2009 has been furnished to the Rafiqul Islam under RTI. This was RTI, my lord. Copy of the resolution number 1 for adopted the governing body of the Mahavidyalaya 17/11/2011. That is the resolution, my lord. Now, resolution number 1 qua. Today's meeting has discussed regarding the select list prepared on the basis of the interview for the vacant post in the Department of English held on 18/9/2011. Today's meeting was found various anomalies on the selection process. It has been said that the select list, no mark has been given against the candidate Sri so and shown him as absent in the evaluation sheet of the so and so expert appointed by the BC Guwahati University, although other 6 members of the selection committee has given the marks shown in the present. Resolution number 1 4. In this regard, today's meeting has been the master sheet prepared on the basis of the interview is defective. For example, 5 marks out of 7 marks have been given marks for knowledge on the subject, and 7 members have been given the marks for the performance in the interview. In evaluation, it is seen that the matter of the knowledge of the subject, series so and so, subject expert appointed by BC Guwahati University has divided by 7 instead of 5 to find out this average. The divided what to have been 5, but divided by 7 instead of 5 in the matter of knowledge of the subject average instead of 7 in the matter of performance in the interview. Hence, the today's meeting has accepted the anomalies. Therefore, today's meeting has unanimously decided to cancel the interview since there is found anomalies in the selection process and sent to the Director of Higher Education for approval. Now, how this gentleman has been deprived by the respondent authorities. Now, the lordship has seen the defect as we have seen from the resolution. It can be cured. Why calling the persons who participated in the interview in the particular time, but it was not done. And resolution was in the year 2011, cancellation was made in the year 2013. This is one of the injustice caused to the petitioners.
You have not challenged this.
That has been challenged. That has been challenged in the earlier 2 writ petition also before the lordships. Other 2 writ petition, we have challenged the this process as well as the subsequent advances. And in the meantime, during this period, he was even terminated by the governing body. That has been challenged by this petitioner. And there was an stay order given by this honorable court. And ultimately he is working till date. So other 2 writ petition regarding the this cancellation of interview and his termination. This is also item number 16 and 17. So for this case is concerned, we are praying for minimum scale of pay till my service is regularized. Now, nowadays, for regularization, net select is required. Net or select or PhD is required. Since he is not having the net and select or PhD, he cannot be regularized. But till regularization, he may be given the minimum time scale, and after obtaining his required qualification, my lord, he can be regularized. At this juncture, he cannot be regularized because the net select and PhD is the, my lord,
At
required.
the time of this advertisement, this cancellation that was cancelled on 7/5/2013.
13.
Whether net slate was not required at that point of time.
That time net select was not required and he was duly qualified because he is having the MPhil degree. Person who have the MPhil degree, they are exempted from the net and select up to 2010. That is the, my lord, point, my lord. So he was duly qualified. But after, my lord, 2010, my lord, it has been opened for the net and select and the PhD degree. Since he was duly qualified, so he was permitted to appear in the interview and he got third position in the interview. First and second did not turn. Then ultimately the interview process was cancelled by the director and permission was given to fill up the post by fresh advertisement. That has been challenged in the item number 16.
So, is there any document to show that the person in position number 1 and 2 did not turn up?
Yes, we have stated specifically, my lord. They have got, my lord, job in other colleges, my lord.
Okay.
Now, so far, my lord, exemption is concerned, lordship, kindly see page 49. We have annexed the, my lord, UGC's guideline, page 49, my lord. Page 49.
Yes.
Yes. My lord, November 9th, 2010. University Grant Commission UGC has decided to exempt all candidates who obtain MPhil degree on or before 10 July 2009 from the so-and-so national eligibility test need to qualify lecturer job. The decision taken in the UGC so-and-so meeting comes a huge relief for the MPhil degree holders. The UGC had last year said that for the post of assistant professor, it is mandatory to qualify the NET. This regulation had invited the strong protest from a cross section of the academic community and also led to multiple litigations, various high courts, including the Madras High Courts. As it is meeting of the UGC noted that the UGC regulations so-and-so are prospective and not retrospective in nature. Therefore, resolved that all the candidates having MPhil degree on or before 10 July 2009 shall remain exempted from the requiring the NET for the purpose of appointment as lecturer. Yes. Because of that, my lord, she was qualified during that period.
Okay.
That must.
Yes, Gopal.
Lordship, in first item, just I referred Lordship, my Lord Justice Bella MTVD judgment. I only want paragraph 14. Just I hand over also. Regarding equal pay, that part I have indicated. And OMS also I hand over also. And regarding second case, Lordship, it will be answered by just one judgment is there. I will hand over the judgment. Everything is there also. The resolution which was placed by the petitioner also regarding UGC Lordship, it was nullified by the central government and it was approved by the Honorable Apex Court in P. Susila's cases Lordship. As per the dictum of the Honorable Supreme Court Lordship, the decision taken by the central government under section 20 of the UGC Act is binding to the Lordship, UGC Lordship. The resolution which was taken by the UGC in the 473 and 74 resolution was Lordship already nullified and it was approved and it was reiterated in our High Court judgment. I just think about it. That particular judgment, everything was discussed. Lordship. Regarding that point, cut qualification can. Even In the year 1997, there is a 1987, there is a Ministry of Human Resource Development guideline also, where that period itself indicated that the net is required. And 2001 itself to 1998 itself, at no point of time NPL was exempted. And it was held by our High Court itself was in various judgment. Only one judgment I am referred, everything is discussed, recent judgment was. Shall I read it? Read it. Lossy, I will hand over, Lossy. I will hand over. That judgment, everything was discussed, Lossy. Regarding Lossy, then required qualification of net Lossy, the exemption part also, even Lossy on the basis of the existing exemption, one government OM was issued Lossy. That was also Lossy, nullified by the Lossy, our High Court Lossy. Even 2015 itself Lossy, prior to the pronouncement of judgment of the PJC Lossy, our High Court itself, my Lord Justice Ujjwal Bhai has passed the judgment Lossy regarding binding nature of the net slate Lossy, required qualification of net slate Lossy. And later Lossy, that was upheld by that similar view was taken by the Honorable Supreme Court 2015 Lossy. After that, decision was first come from our High Court Lossy. After that, it was from Allahabad High Court, then Honorable Supreme Court Lossy. I'll be hand over the judgment Lossy, everything is reflected Lossy, that part Lossy. Regarding qualification part and everything Lossy.
No, that interview was cancelled not because of the qualification, but because of
It was a
anomalies in awarding.
anomalies by the anomalies was Lossy by the anomalies was Lossy found out by the governing body. That part we cannot Lossy. That part, if anomalies is there, that we cannot act upon. Even that was not, that proposal was not forwarded to the us also. Even Lossy anomalies is not there. Then the first candidate which was selected, number one candidate, he should be forwarded to the government also. There is no provisions for waiting list. If Lordship, for a moment, my Lord may held that particular selection was conducted with following all the procedure, there is no any violation, no any anomalies. Then also the duty of the governing body to forward the name of the first candidate. Whether he has joined or not, it is a different thing also. If one person after appointment of the Dibrugarh University, if he appointed in the Cotton University, if it is fifth choice Lordship, he can come to the Cotton University also. He can come to the Central University also, Tesco, if he appointed later on that particular university Lordship. We cannot divert the persons that you already joined in one institute, you cannot take part in another institute, your service cannot be given to another institute. That cannot be Lordship. If today Lordship held that the particular interview process was, everything is fine Lordship, then also it to the first candidate Lordship, not to the second or third candidate Lordship. Qualification part, that judgment will be reflected Lordship.
Okay. Third, Mr. Mandal, Learned Counsel for the petitioner. And Mr. Gogol for the respondent of the argument concluded. Judgment is out.
Malata, one point Malat query to my friends Malata submission regarding qualification. Page 55 Lordship LDC for a moment, Malat. Page 55 regarding qualification, Malat. Page 55. Not after cancellation of the Malad earlier interview process, Malad, fresh advertisement has been Malad permitted by the director. Page 55 Lordship LDC. Malad, there are only two lines, Malad, in the first paragraph. Lordship will find assistant professor candidate, those who have obtained MPhil degree on or 10/7/2009 may also apply for the post, excluding the candidates obtained so and so from the campus so and so. Now that has been issued on 4/12/2015. My friend referring the circular 2010, this is the action of the director in the year 2015, maintaining the same position.
That will be answered by that particular document. That will be answered by that particular document. I don't have the
That is holding the
everything
field.
is answered. I am not saying everything is answered that particular document.
Okay,
That was already set aside in 2015 itself.
okay, we will resume after 5 minutes. Yes.
So, my lord, we have completed our part. My lord, we are submitting the my lord, written argument as well as the my lord, citation, marking the presentation number. Development.
Turning item 6.
I have received instruction worship. I already have to handle. We would like to file affidavit. In this case.
They have already filed the affidavit.
Yes, because new facts are coming, worship. My name kindly peruse scale number 5. And the petitioner have to reply. Against the rejoinder, worship, we have obtained instruction. It's a serious allegation. So
No, Lord, I have a submission, my lord. This serious allegation, light allegation, heavy allegation, that will be the subject matter of the disciplinary proceeding or maybe a criminal case. We are not on that. My lord, I have challenged my suspension. Can suspension take this particular form as has been done? Earlier I was suspended. This honorable court interfered. Again, I have been suspended. So therefore, my submission was, my lord, whether suspension can assume the character of a punishment. If I am guilty, please send me to jail. Please dismiss me to whatever you like by following the process of law. But as of date, my lord, we are assailing the suspension. How can there be a successive suspension, my lord? That's my case. If there are allegations are there, let them come. I mean, inquire, my lord. We are not questioning those.
suspension in respect to earlier suspension and the present suspension is another new grounds. And that particular suspension, second, we have already reviewed it. All procedure is followed. If lordship want to peruse the record, I can place the record also.
No, regarding suspension, lordship will kindly, pass an order. Otherwise, my lord.
Suspension, lordship, that suspension was under new grounds, lordship, and that suspension was reviewed within a stipulated period prescribed by the lordship. Law as well as the lordship dictum given by the Honorable Supreme Court. There is no procedure.
Let my learned friend conclude, then I'll make.
No, first let the petitioner.
My lord, what had happened in this case, by an order dated 4/1/23 at page 31, I was placed under suspension. 4th of January 23. In pursuance of the letter received from the president, same president, governing body Uttar Borpeta College so-and-so, by letter dated so-and-so, regarding arrest of Zahir Ali, principal of the college, pending trial of departmental proceeding, Zahir Ali is hereby placed under suspension with immediate effect. Well, what is most significant to notice in this suspension order is, this is not a suspension under 6(2). It's not a deemed suspension. It is a suspension under Rule 6(1) because it says pending trial of departmental proceeding. It's absolutely permissible. We are not questioning this. So this was a suspension under 6(1). Then my lord will kindly come to the Honorable High Court's order at page 37. And the operative portion is at page 39. Accordingly, the instant petition stands disposed of with the following observation and direction. The further continuance of suspension of the petitioner on the basis of the order dated 4/1/23 is contrary to law laid down by the Supreme Court in case of Ajay Chaudhary, and as such, respondent number 2 is directed to forthwith reinstate the petitioner. So, my lord, the suspension order was interfered with. Then, my lord, at page number 42, I was reinstated, my lord, but I was posted in another college at page 42. Thereafter, my lord, page 43, I joined same college, my lord. Thereafter, my lord, I was sent back to my original college. Now the impugned second suspension order is at page 54. Whereas an inquiry committee was constituted by letter dated 23/10/24 to inquire into the allegation into the matter of financial irregularities alleged to be committed by Jahir Ali, principal comes so and so. As per the preliminary inquiry report received on 23/11/24 from the inquiry committee, comprising of Sri so and so and so and so, have been committed by the principal. Therefore, the undersigned is satisfied that it is necessary to place Mr. Jahir Ali, principal cum DD of Uttar Barpeta College, under suspension from service with immediate effect in the interest of public service. Now, therefore, pending royal of departmental proceeding, Jahir Ali cum principal is placed under suspension under Rule 6(1). So earlier order was also under Rule 6(1). Second order is also under 6(1). Well, prima facie, the rule does not permit successive suspension, number one. And number two, my lord, these are the complaints which are already dealt with. The rule does not permit. Had the earlier suspension been a deemed suspension, then also things would have been different. Now, my lord, apparently this action was taken at page 54. Kindly see page 53, my lord. This is a gentleman called Nayan Kumar Pathak. He is a joint secretary. Now, in his capacity as a joint secretary, my lord, he directed the director and he passed the order in his own capacity. Kindly see page 53. With reference to the subject cited above, I am directed to forward herewith a complaint petition dated submitted by President, governing body, which is self-explanatory, and request you to take prompt action on the matter as per government letter and submit an action taken report to the undersigned. Who has sent it? Nayan Kumar Pathak. Now please come to next page, my lord, 54. Now he was in charge for some times, my lord. He passed this order. Director in the capacity as a director. As a joint secretary, he is directing, and as a director, he is passing. The regular director perhaps was not there. As a part-time, he was in charge. So he has passed the order.
15 days.
Huh?
15 days.
And my lord, this at page 55, it was received by me 15 days later on 14th of February.
17 days.
Page 54 is the order of suspension. Page 53, he directs as a joint secretary. Page 54, he passes the order. And kindly see, my lord, though it is said that it should be given to the person concerned, it was not given to us. But the director has informed me on 14th, my lord. 14th February at page 55. And all these allegations, my lord, are old allegations. And earlier, my lord, the earlier governing body of the college had placed everything, has been taken note of. If I am guilty of forgery, if I am otherwise guilty of so many things, then law will take its own course. But as of today, we are concerned with the suspension order. Whether the suspension order in its present form, it can countenance legal scrutiny. My humble submission is, my lord, there's nothing. Now, if your lordship kindly takes the affidavit filed by the government today,
Reply this one.
now if your lordship would kindly come to the government affidavit at page 62. Page 62, my lord, just to show, my lord, that these are all old and stale charges. 24/3/25. Preliminary inquiry was conducted to investigate the financial irregularities during your tenure as a principal on the complaint letter received from various sources of your college, including President Governing Body, Mohammed so-and-so. The findings are as follows. Observation regarding infrastructure development of Uttar Barpeta College for the year 2017-18. I'll show me lot. These are all settled. 2. Unauthorized absence from duty of Saifur Rahman. Then Milord, that was not even my responsibility, it was director's responsibility. And regarding some fishery lease. Now, Milord, if your lordship kindly comes to my reply, prima facie to show, Milord, that these allegations are all old and stale and already dealt with. If your lordship would kindly come to the affidavit in reply, page 75. Now that some money was given for construction, it was completed, Milord. This is certified that infrastructure development of Uttar Barpeta College, balance work of first floor and ground floor of an RCC building, interlocking concrete block pavement, college gate with part boundary, sanitation, installation of electric equipment, supply of library, etc., have been completed as per estimated value amount of rupees 1 crore as per the installment. So this is by the competent executive engineer. And Milord will kindly come to page number 79 to 83. These are the utilization certificates. Their allegation is that utilization certificate is not there. Page 79 to 83 are the utilization certificates. Then regarding the second charge, Milord, I'll have your lordship's kind attention to page number 90. I wrote to the director, Milord, with reference to the subject cited above, I have to inform you that Saifur Rahman is found many unauthorized absent and negligence in his duties on so-and-so to so-and-so, that is 82 days for the year 2022. In these unauthorized absent, I have been informed to this department time to time, but still till date found no any result. Therefore, I would like to request your honor kindly to take appropriate action at the earliest convenient for interest of the college. I wrote as a principal wrote, then please come to page 89, Milord. No, sorry, page 91, Milord. Sorry. Yes. Because since he's a government employee, Milord, I cannot take step. With reference to the subject cited above, the director is writing to the petitioner. I am direct to take earned leave application from Saifur Rahman for the days improperly absent and to apply extraordinary leave if not covered by leave period in credit. So director in turn says, you see, take an application from him and you adjust it against the earned leave. So what is the charge, Milord?
107. Fishery leave.
Yes. Then regarding the third charge, Milord, Milord may kindly come to page 107. Resolution number 6 at 107. This is, Milord, it starts at page 106 of 39/2019. The GB held they on so-and-so discussed about the fishery lease amount matter for consideration. Fishery was damaged in natural calamities like overflood, dry season, and damage of embankment. And the lease were lost about 4,50,000 in different years. So DB to the resolve for considering the said amount for the loss. So the issues are settled, Milord. If somebody wants to dig out, they can do. But end result, what will happen? So why the suspension is necessary? Therefore, my humble submission is, Milord, it is an abuse of the process of law. This Mr. Pathak, that joint secretary, he must be impressed with the complaint. Therefore, he directs the director. Then for some time, the director was not there. So he was in charge, so he passed the order. So therefore, my humble submission is, Milord, End of the day, one principle is very well settled. Suspension cannot assume the character of punishment. Idea of suspension is not to punish anybody, but the manner in which the suspension has been resorted to, as if suspension is a punishment. And that's the tenor of the argument of the government advocate also. Charges are very serious. If charges are very serious, hold a proceeding, find me guilty and punish me. Lodge an FIR, cause a criminal prosecution, do that. But that has got nothing to do with the suspension. And therefore, my humble submission is, my lord, lordship will interfere with this order of suspension. That is my humble submission. Is that how? Lordship's kind permission for the under matter.
So Lordship may kindly come to page 31. I will answer a big point raised by my senior one by one, Lordship.
Page number?
Page 31. This is the suspension which was issued earlier, Lordship. There is a argument is there, first suspension and second suspension. Argument is there, first suspension, second suspension. My reply is that it is an earlier suspension, it's a later suspension. An earlier suspension, on what ground it was suspended? That particular person was suspended for misutilizations and Lordship the fraudulent transfer of the National Scholarship Fund, Lordship. That's why he was behind the bar, Lordship. At the relevant point of time, that's why he was suspended, Lordship. Wrong quoting or non-quoting of the provisions does not fatal a Lordship, does not get the particular order, Lordship. Here there is no provisions of quoting of the Lordship. Disciplinary proceedings rules, Lordship, 1964 rules. It only says that that particular person was hereby placed under suspension with immediate effect. The reason is that that particular person was behind the bar, Lordship, more than 24 hours, Lordship. Even he got bail after 10 to 15 days, Lordship. That is the reason first suspension was, Lordship, imposed to the petitioner due to the misappropriation, misutilizations, and wrong transfer of the scholarship funds of the National Scholarship Fund, which is for the basically minority communities, Lordship. That is the first suspension. Now, and before now as for the petitioners, that second suspension, Lordship. And my view is that it's a later suspension, and regarding that letter which was referred in page 53. That letter was issued by one Mr. So-and-so, Lordship. He is in the capacity of a Joint Secretary of Higher Education Department, Lordship. That gentleman was yesterday came before your Lordship. That pension matter, Lordship. And my lord may kindly mark the date. The date was 06/01/2025, Lordship. It was issued to the then Director, Lordship, by the Joint Secretary of Higher Education Department as a capacity of Joint Secretary of Higher Education Department, not as a capacity of a particular individual, Lordship. It was issued on 6/1/2025. And then my lord may kindly come to next page 54, when the pension was imposed, Lordship, on 28/1/2025, Lordship. As because at the relevant point of time, Lordship, the director was leave due to the examination of his child, Lordship. That's why he is the in-charge director at the relevant point of time, Lordship. It is not the case that he is holding the same post and pass the same order, Lordship. And that particular suspension order was on the basis of an inquiry constituted by the competent authority, Lordship. And inquiry found various anomalies, Lordship, regarding construction of building, Lordship, more than 1 crore rupees, Lordship, and other fishery matters, Lordship, and other, Lordship, and other is, Lordship, on the unauthorized absence of a particular person's, Lordship. Totally new 3 grounds, Lordship. It is not related to the earlier suspension order, Lordship. Earlier was on the basis of misutilizations and transfer of the fund to his own account, which was for the especially for the minority community student, Lordship, by the central government, Lordship. He has misused the fine, he has gone to the jail, he was behind the bar, So he was suspended, Lordship. Not relation with the present suspension order, Lordship. And that suspension order was issued on 28/1/2025, and charge was Lordship within the time 24/3/2025. Within the stipulated period prescribed by the disciplinary and appeal rules, Lordship. And Lordship, review was also done within the stipulated period of time as the dictum of the Honorable Apex Court, Lordship. There is no procedural lapse, Lordship. If my lord found any procedural lapse, and my lord found that, and my lord assumes that, my lord held that, that particular person was suspended on the same ground, Lordship, twice, then Lordship can interfere. I can also say that, Lordship, that suspension itself in paid, Lordship. But that particular suspension, present suspension, is totally a different footing and different charges, Lordship. And all the procedure prescribed by the statute is followed, Lordship. There is no violation of the single procedure. There is no violation of the dictum of the Honorable Apex Court, Lordship. And that particular suspension was on the basis of an inquiry report submitted by the competent authority, Lordship. And on the basis of that, that suspension was done, Lordship. And by way of reply, they had come with a certain documents to resist the charge which was framed in the charge sheet, Lordship. And as per the instruction received from the authority, Lordship, that all the documents are false one, Lordship. The document which was annexed from page 89, 98 onwards, Lordship. 98 onwards, Lordship, to 105, Lordship. All documents are false document. So accordingly, my friend is appeared for the college also. They have lodged an FIR, Lordship, regarding that. After gone through that particular affidavit, the whole picture is come that the documents are totally false.
Page number 95.
98 onwards, Lordship. 98 to 105, Lordship. That resolution part, Lordship. Basically, that resolution, that it's a not type copy, Lordship. Not type copy, Lordship. The so-called GB's meeting resolution, Lordship. As far as GB is concerned, Lordship, GB says that meeting was not there and no resolution was taken, Lordship. And page petitioner is playing with the courts, Lordship. He has submitted false document before your Lordship, not the executive, Lordship. Then, Lordship, page 79.
No. What document is available with you to suggest that this GB resolution is first?
There is non-existence, Lordship. FI is also lost.
Have you filed your affidavit?
We have filed. That was come later on. After we have filed affidavit, they have filed reply. In the reply, they have annexed that particular document.
Okay.
Against that document, we have obtained instruction today. That's why I paid before your Lordship that we place it by way of affidavit. And against that also, Lordship, the college authority has filed FIR also, Lordship. And other, sorry, Lordship. This is the FIR, Lordship. And other documents. Yes, sir. Even lordship, that particular person who is the assistant professor, he has also given one letter lordship where he have stated that he has not signed it lordship. He has not signed that particular meeting lordship. This is the one document lordship. This is the conduct of the petitioner lordship. GB come up with a lordship, FIR lordship against the document annexed by the lordship, that particular principal lordship.
Okay.
And lordship, other documents which is annexed in page 80 onwards, lordship, utilization certificate, it is not by the competent authority lordship. When the fund was lordship given from the Assam government itself lordship, and from the UGC lordship, from the Ministry of Human Resource Development Department lordship, there is a branch in the Director of Higher Education lordship. It's an audit and account branch lordship. They have verified and certified whether that particular fund was properly utilized or not. After that, they have issued a utilization certificate. That page 80 onwards, the utilization certificate issued by so-called chartered accounts lordship, it's a private entity lordship. It's not by lordship department lordship. In any colleges lordship which are under the lordship state of government of Assam lordship, Higher Education Department, all the funds come from the state as well as central as well as UGC lordship. All are audited by one of the branch of our department. It is called the Accounts and Audit Department lordship. They have verified. After that, they have issued the completion certificate lordship. So lordship, my humble submission before lordship is that there is no any interlinking and there is no any relation with regard to the suspension order which was issued. One page. 4/1/2023 lordship and 28/1/2025 lordship. 4/1/2023 suspension order is lordship in respect of misutilizations or fraudulent transfer of the lordship National Scholarship Fund, for which he was gone to the jail lordship. On the basis of that, he was put under suspension lordship. And lordship, the suspension order which was issued on lordship 28/1/2025 is totally in other grounds lordship. It is on the basis of the inquiry conducted by the department regarding various anomalies lordship, regarding utilization of more than 1 crore lordship the UGC's funds for constructions, and lordship the utilization of the fisheries also department, other part also lordship, fishery list part and other part. A totally defined ground lordship. Defined ground, he was suspended, and within the stipulated period of 90 days lordship, charges was issued lordship, and DP is also going on lordship, and within the stipulated period and as per the dictum of the Honorable Supreme Court, review was done on time lordship. There is no any procedural lapse lordship. In view of this lordship, at this point lordship, my humble prayer is that lordship may not interfere with the suspension order lordship. There is no procedural lapse, there is no violation lordship. And the conduct of the petitioner itself is doubtful lordship. He has submitted a document before your lordship, and which as part of view of the governing body of the colleges, it's a false one lordship. And they have also instituted a FIR. The person concerned whose sign is there, he also says that he never signed it lordship. This is my humble submission.
Subject to the argument of my senior lordship, may I reply lordship? 1, 2, 3 point lordship. 1.
Pardon?
I want to reply only 2 point of my friend
Okay.
lordship. If lordship permit lordship.
Yes.
Subject to my senior argument lordship.
Okay.
Lordship, first part regarding the scholarship lordship.
Hmm.
Kindly see the FIR lordship, page number 28 in the petition lordship.
Yes.
This is the FIR, Lordship. The FIR was lost by one police personnel, Lordship. For as a whole, all the district, Lordship, my college name is not there, Lordship. Here is the FIR, Lordship. Lordship, kindly find out the FIR. My college name is not there. I am not with the connected with the LS offense also. And in this respect, Lordship, I'll place one order from the UGC, Lordship, page number 34. Earlier, my senior was placed, Lordship, page number 34. So in the FIR, they have mentioned about the scholarship anomalies, Lordship. UGC is the head authority, Lordship, who will sanction the all scholarship regarding the college, Lordship. UGC clarified page number 34, kindly see, Lordship, clarification regarding the Ishanuda scholarship for any year to Uttar Borpeta College, my college, Lordship. This is the reference to letter number 1009 dated 30/12/2022 on the subject cited above. In this regard, it is informed that no student was elected from Uttar Borpeta College, Assam under Ishan Uday scholarship for any year in 2020-21, 2021 to 22. LS, this LS offense, Lordship, mentioned in the FIR, Lordship. Also, no scholarship amount has been processed to the students of this college under the scheme. Only UGC is the sole authority. They can find out whether scholarship is given or not. This is the clarification. Next,
That's all
Lordship.
right. If that was the allegation in respect of the first
Yes,
suspension order,
I will place.
then the
Lordship.
subsequent allegation has no relation with the first one.
Yes, kindly see, Lordship. I will place it. One IA, Lordship, filed by the managing committee president, Lordship. Kindly see. That was already disposed of for impleadment, Lordship. 792/25.
Yes.
So everywhere, Lordship, in the director order and joint secretary order, they have mentioned that on the basis of some public complaint and complaint from the president, they have been suspended, me, Lordship. Although in the charge allegation, they have mentioned all the allegation before 2022, present president and present committee from 2022, and all the allegation is earlier committee. Present committee is filing complaint again and again, Lordship. He is not connected with the earlier committee, Lordship. Kindly see the complaint, Lordship, page number 9 of this IA, Lordship. Here is same thing they have mentioned. One allegation is from 2013, Lordship. Some misappropriation of 40 lakhs they have mentioned. In last paragraph, they have mentioned UGC fund, mismanagement of UGC fund, scholarship fund. Earlier, I have suspended on the basis of same allegation, Lordship. UGC fund and college misappropriation, everything, Lordship. Same allegation precedent given, Lordship. And public complaint also same, Lordship. In the writ petition, page number 44, kindly see, Lordship. Although they have pointing out in the charges, they have mentioned the different point, but all the point already settled before 2022, Lordship. And UC is important, Lordship. 1 crore rupees UC we have submitted, Lordship. My senior already mentioned, Lordship. When we have already placed the 1 crore rupees UC is utilization certificate, and at that time, no question from the department, from the director, from the commissioner, Lordship. Now the president questioning, Lordship. My senior friend also submitted on the basis of the president allegation, Lordship. He said that present president said that these resolution are false. When the 2018, 2017, 2010, there is no objection from the earlier committee. How the present committee said that these are the false allegation, Lordship? Their submission is completely wrong, Lordship. And kindly see the allegation from the public, Lordship. Page number 44. Here is also same thing, Lordship, UGC fund 2013. My college is provincialized in 2013, Lordship. Here is the allegation of 2008, 2009, Lordship. When my college is not provincialized, Lordship. I am the founder principal of this college, Lordship. One opposite party, they filing again and again complaint, Lordship. On the basis of that, the director and the other officer taking the cognizance, Lordship, against me. And I'll show the letter, Lordship, from the officer, Lordship. Kindly see. Page number 51, Lordship. 51 and 53. First, kindly see, Lordship, page number 53. May I read this, Lordship? With reference to the subject cited above, I am directed to forward here with a complaint petition dated 2024 submitted by the President, governing body. So this is the complaint from the President and governing body, from which they have taken action, Lordship. And in the subject, kindly see, Lordship, subject is complaint against the director, Lordship, Director of Higher Education, for delay action. When the director delay, this present officer, Nayan Kumar Pathak, he came to the in charge and he taken action, Lordship. But director not taken action. This is written by the Joint Secretary. He filed complaint against the present director, this present director, Lordship. Completely personal interest, Lordship. And all allegation and earlier scholarship fund and present also same, Lordship. And these are the UGC, Lordship. I'll take it 1 minute, Lordship. Our reply, Lordship. Rejoinder, Lordship. Page number 84, resolution of Uttar Barpeta College, Managing Committee, Lordship. This is the date of 2018, Lordship, when present committee is not there, Lordship. It's a come up after 2022. So the resolution number 1, the governing body Uttar Barpeta College, its meeting 2 is the resolution, Lordship, held on 27 July 2000 with Professor Abdul Samad Ahmed, President. At that time, President is Abdul Samad Ahmed, Lordship, and present President is different. So at that time, that President never filed any complaint against me, and all things are settled at that time, Lordship. At present, the present committee against the principal, Lordship, he filing complaint again and again. On the basis of that, the present suspension, again they have been suspended me, Lordship. And today they're saying that we are filing a complaint today. The affidavit filed by the President, kindly see, Lordship. Filed by the President, respondent number 4. They have filed it recently, Lordship, 23/4/2025. What is their stand, Lordship? Not a single Lordship, against me. Kindly see. Not a single word they have written their affidavit. Now they're saying that on the basis of President instruction, they have taking time and they placing the everything, Lordship. Where is the reply from the President, Lordship? Kindly see. Not a single word from the President. Okay. So just my argument. Our prayer is, Lordship, let the DP continue, Lordship. I may be reinstated and suspension may be set aside.
Heard Mr. Ken Choudhury, learned senior counsel, assisted by Mr.
A.U. Ahmed.
Learned counsel for the petitioner and Mr. Gogoi for the. Sir, your name, please. P. Boregi, learned counsel for the respondent number 4. Anything to submit?
Regarding rejoinder affidavit, before they file the rejoinder affidavit, I filed the affidavit. I find it on their rejoinder affidavit that on 10/12/2023, no GB meeting was held on, and therefore
In this regard, we have filed a FIR against the principal, Lordship. And one of the member of the meeting who was shown as present in that meeting, he has given a letter to the director of director of higher education that no meeting was held on and he was not presented in that meeting. Therefore, the principal is the most corrupted person, Lordship, and he has filed before your honorable court a false document, Lordship. That's why his suspension is not his suspension is Lordship reinstated or Lordship he is reinstated in the post of principal, then there is a very chance to hamper or temper the evidence of the documents of the college, Lordship. And regarding Lordship, after suspension, he has given notice on 2 or 3 times. And after getting the notice, he already give written that he will submitted the documents before the concerned authority, but till that no submission has been made by the principal, Lordship. So, Lordship, he may not be reinstated. His suspension should be stayed on.
Okay.
They are saying everything verbally, Lordship. There is not a single
No, no,
record,
Lordship.
Lordship.
I have already.
Everything, Lordship.
Okay. Argument concluded, order is out.
All right.
Timing item 5.
May I please, your Lordship. Lordship, kindly peruse the order dated Q4 2025, Lordship.
Yes, Mr. Saul.
My lord, yes, I have received one instruction from Inspector of School, my lord. Here it is stated that I would like to inform you that second paragraph. I would like to inform you that the concerned petitioners Sri Govindo Kumar Bhuya and Moinul Haq Chaudhary along with others were originally appointed under the OBB scheme. Subsequently, they were adjusted against vacant posts in upper primary school and accordingly commenced their services at Sutirpara ME School and Kadamoni Town ME School respectively. Furthermore, the petitioner along with other similarly situated teachers were sanctioned area salaries as per government letter number so and so dated 19/3/2014. Seeking further relief, the petitioner letter approached the honorable court in WPC so and so for release the increments that are due to them since 1998 and conferment of pensionary benefits as per provisions of Assam Service Pensioner Rules 1969. While they eventually received incremental benefits with effect from 1/7/2019. Increments accrued during the period 1/4/1999 to 36/9/2019 have not yet been received owing to amalgamation of the Sutirpara ME School with Sutirpara High School and Kadamoni Town ME School with Kadamoni Town High School as reported by respective headmasters of the school. But at that period, the petitioners were absorbed or were appointed in the LP school, ME school.
So my lord, elementary department is the appropriate authority for that my lord, sanction of that. Because under the elementary education, they are appointed.
May I please, your
After
lordship?
amalgamation, my lord, they come into the secondary education department.
May I please, your lordship? Lordship, after amalgamation of the school, the employee has submitted all the documents related to their service has been submitted before the secondary education. Now they cannot ask elementary education for any grievance. So it is the secondary department who ask elementary department if they need any information, lordship. That is why we cannot, that is why we have not implement party, the elementary education as a party. Because if now we cannot ask elementary education for any information or any grievance. Because we have submitted all the documents relating to our service before the secondary education after amalgamation, lordship. Now, if any need of information, they have asked elementary education, but we cannot, lordship.
After all, my lord, all the documents will come from the elementary education department, my lord.
But it is
To
not
the
for-
secondary education department. Here, my lord, one case is referred in this writ petition, my lord. WPC 2819/2023. Here, my lord, elementary education was the party only, and here
Their school
the
has not been
petitioner's
amalgamated.
prayer was for release the incremental benefits due to petitioners since the year 1/4/1999 to 36/2019, similar to our petitioner. On last that the court directed the standing council to obtain instruction. And my lord, here it is in para 4, my lord, page 45. Para 4. Upon hearing the learned counsel for the parties, the court is of the view that the writ petition can be disposed of with a direction to the respondent authorities to expeditiously pursue the supplementary demand proposal submitted before the government and for according sanction after receiving budget after receiving এটু কি হয়?
Budget হচ্ছে,
Budget.
এটা মানে
Ba-
করতে গেছে।
budget communication and thereby take all necessary steps for release the area increments to the petitioners. So my lord, here directed the elementary education department. Direction was given to the elementary education department.
That school has not been amalgamated, lordship. Now they are, at the time of amalgamation, at the time of amalgamation, all the documents relating to their service, they have submitted before the secondary education. Now the secondary education is not, cannot question about this, to implement the elementary education as a party here. It is their duty to ask any, they need any information, they can ask. Any documents or any information. We cannot ask elementary education.
My lord,
Department
sometime
may
may be
ask
granted.
also.
Sometime may be granted, I can take the instruction and the department will obtain,
Last occasion
obtain whatever required from the elementary education department, my lord.
They, on 2nd of April, they have also submitted, we bring instruction. Last various occasion, they have taken time to bring instruction, lordship. In 21, 22.
The period for which they paid for increment is 1999 to
1999
2019.
to 2019.
They are entitled to the benefit. You release the amount.
I have to take instruction regarding that.
instruction you were
That
required?
instruction will come, my lord, from elementary department to secondary education department, and then secondary education department will communicate with me, my lord. So sometime maybe granted that I get the instruction from the department.
So in the year 1999, you were in the
They got the years.
lower
salary
primary
also.
school.
Yes,
Yes, yes.
under the elementary education department.
But at the time of amalgamation, all the documents they have submitted before the secondary education.
Third is M. Sarma, learned counsel for the petitioner, and Mr. U. Sarma, learned consulting counsel for the respondent in secondary education department. Mr. Sarma, learned consulting counsel for the respondent in elementary, secondary education department, praised for granting him some time to obtain further necessary instruction. Here is accordingly allowed to list the matter after a week in the event of failing to obtain necessary instruction on next day. The court will proceed to dispose of this petition on the basis of materials placed on record.
See, matter will be made as part heart instead.
This shall list the matter as part after a week.
Highly obliged.
Yes, with your lordship. That morning I have mentioned item number 40, my lord, but could not inform the petitioner, my lord, he is present.
Lordship, my learned friend is trying to mislead this honorable court. Kindly, Lordship, have a look, order dated 19/3, Lordship. It was categorically submitted at the bar, the buildings are complete. Now
No, my
she's
lord.
taking another play.
And in respect to item number 40, my lord, no affidavit is filed, my
No,
lord.
Lordship.
My lord,
He holding the brief to 40. He wants to file an affidavit, Lordship.
No, Lordship, already irrigation department,
Okay, let her file affidavit.
already matter has been placed before the finance as per their submission, Lordship. They have no role to play as of now.
Okay, let them file affidavit. We'll list the matter after a week.
2 weeks, your lord.
Lordship, they have a strict direction, Lordship. To file the affidavit by 5/12, Lordship, 2023.
Maybe, she would not be able to file the affidavit, should we reject her pair?
On last occasion, it was recorded that no further adjournment will be granted. That order was passed in their presence, Lordship.
But there was no indication that she has not filed any affidavit.
Lordship is taking up item number 40 or what?
Yes.
Kindly have a look, Lordship, order dated 19/3/25 in WBC number 2804, Lordship. It is submitted at the bar that the pleadings of repetition number so and so are complete, which should cover repetition number so and so. My learned friend was present at the time, Lordship. He did not raise any objection.
Okay, let her file the affidavit. We'll list the matter after a week.
A fix that may be given, Lordship, kindly.
Pardon?
A fix that may be given, Lordship. I'm suffering from 22, Lordship.
Okay, as agreed by learned advocates of both the parties, recess shall list the matter after a week on. In the meantime, Miss.
DS new, your honor.
Yes?
New.
Learned standing counsel
Yes,
for
irrigation department.
irrigation department may file her affidavit in opposition.
Sure.
Filing which the court will proceed to hear and dispose of the matter without the affidavit of the irrigation department.
Timing item 8.
In this case, the pleadings are complete in item number 8. Matter can perhaps be taken up for hearing, any convenient date, not on a hearing date.
Okay. Both the parties are represented by their English counsel. It is submitted at the bar that pleadings are completed and the matter is ready for admission hearing. Accordingly, it is provided that recessal is the matter of
In the month of June, Lord.
June.
10th June.
10 June.
Lord. Timing item 9.
Well, the same prayer is there.
Same.
On the 10th.
That becomes 17th. Not same date.
Obliged.
Item number 18.
May I please, your lordship. The matter relates to non-release of pension, lordship. Lordship, on 23rd April, lordship,
Council for the Finance Department submitted an instruction that bank will clarify as to why pension has not been released. Finance Department also Lordship submitted Lordship after making first payment Lordship, they forwarded the PPO to the bank. And thereafter payment has not been made. Actually, payment was made till the date of my husband Lordship. After the date of my husband Lordship, it has been stopped. Despite my repeated process, even after sending the legal notice also Lordship. This is the case Lordship. And in this regard Lordship, bank was directed to take instruction Lordship.
Yes, Mr. Sen, any instruction?
Yes, my lord, we have received instruction, my lord. My lord, what has happened in the, my lord, PPO, pension payment order, my lord. Rashid, kindly have a look, my lord. My lord, her name is inadvertently written as Abanya, my lord, instead of Lavanya. That is why, my lord, the payment was not made to the petitioner, my lord. My lord, let her get rectified that mistake, my lord, from the treasury office, my lord, because this is the issued by this payment order has been issued by the treasury office, my lord. And
No, this order is issued by the director
Director
of
of
pension.
pension.
director of pension, thereafter forwarded to treasury,
So this has to be corrected by the
director of pension, correct.
For that Lordship, bank has to return back the PPO Lordship to the treasury Lordship, and the treasury will forward. So far my understanding Lordship, and the director of the pension will rectify Lordship. And I have no scope to rectify my documents Lordship.
No, my lord, later approach the director.
No Lordship,
Showing
PPO is
this-
pending before the Lordship,
showing-
bank Lordship.
showing-
Until it is returned to the treasury, it cannot be rectified Lordship.
We have repeatedly, my lord, informed the petitioner, saying that there is a mistake in the PPO. Please rectify it. My lord, she did not respond to it.
Lordship, how can I?
Therefore, my lord, we could not release the amount. That is the difficulty, because unless the name is rectified, my lord, admittedly, your lordship would say, my lord, instead of Lavanya, it is written as Abanya, my lord. I have underlined it, my lord.
Yes,
Paragraph
I have
number.
seen it.
Yes, my lord. So unless it is,
Mr. Sen,
my lord.
can you return the matter to the treasury, clarifying that due to mistake in her name in the PPO, the amount would not be credited in her account.
My lord, that I can
On
do.
basis of that letter,
Yes.
treasury can write a letter to the director of pension. Yes, madam, for director of pension. Heard, Mr.
It's the Lordship.
Learned counsel for the petitioner. Also heard Mr. PK Sen, learned standing counsel for the SBI.
Respondent number 1 and 2, my lord.
Respondent number 1 and 2. And madam for respondent number 5. Respondent number 5. Pardon?
Respondent number second.
Ms. Musari for respondent number 4. Person to order dated 23/4/2025. Mr. PK Sen, learned standing counsel for the respondent number 1 and 2. Submits that he has received instruction from the respondent number 1 and 2. Then as per his instruction, there is mistake in the name of the petitioner, for which the bank would not release the amount in her account. Accordingly, it is provided that in view of the instruction received from Mr. Sen, it is provided that the respondent number 1 and 2 shall write a letter to the treasury officer of
Morigaon Lordship.
treasury officer of Moregaon, informing the reason for failing to credit the amount of pension in the account of the petitioner. Within a period of Mr. Sen, 1 week?
7 days, yes.
7 days.
10 days. my lord.
10 days, within a period of 10 days from today. On receipt of the same, the treasury officer, who is representing treasury officer?
Finance department also.
Okay, finance is a party here.
Party there, the treasury officer is
Treasury
under
officer.
the.
Mr. Solia is available here. On receipt of which the treasury officer, Moregaon, respondent number 3, shall communicate the matter to the Directorate of Pension, Assam, for making necessary correction in the pension payment order of the petitioner. Place the matter after 4 weeks. After 4 weeks. The instruction placed on record today, placed before the court today by Mr. Sen, shall be part of the record.
Deeply obliged.
Obliged, Lordship. At number 19.
During this matter, Lordship, pleadings are completed, Lordship. Lordship, can it be taken up on Thursday, Lordship, on a hearing day, 22nd, Lordship?
So in the month of June,
If you late lordship.
On 3rd of June,
Pension matter, my lord, lady is quite full.
3rd June,
but the parties are represented by their case counsel. It is submitted at the bar that lettings are completed. And the matter may be listed for admission hearing. Accordingly, it is provided that this is the matter on
21st.
the first.
Must have.
Item 20.
goodbye. 21st. Lordship, here in this matter, instructions are awaited, Lordship. Can this be taken up after 2 weeks, Lordship? 2 weeks, Lordship. Regarding Lordship, leave encashment and GIS only, Lordship.
Leave encashment and the group insurance scheme is, amount is not released to the present
Petitioner.
petitioner. And since 2021 he retired, since then he is not receiving.
Get the instruction, Lordship.
Heard, Mr.
DK Bordoloi.
DK Bordoloi, learned counsel for the petitioner. Also heard Mr. T. Upamanya, learned standing counsel for the respondent, say, fire petition.
1 and 4, Lordship.
1 and 4. Respondent number 5 and 6. Your good name, please.
8.
8 us. Mr. Sharma for respondent number 3. Respondent number 3, AZ. Respondent number 3, AZ. Mr. Upamanya submits that instructions are still awaited and placed for listing the matter after 2 weeks. We are allowed this is a list
Can,
after
can,
2 weeks.
Lordship, can it be fixed on 30th of May?
30.
30.
Okay. Highly obliged.
21, 22.
May I pray? Also in this matter, lordship, I pray for some more time for filing our affidavit, your lordship.
Lordship, may I kindly see the last order, Lordship? Lordship, may I kindly give a short date because since 2020, Lordship, litigations are pending, Lordship. In both cases, there are interim. In the item number 22, Lordship, there is an interim order to not to fill up the post of headmaster. So since long, Lordship, that school is also without permanent headmaster, Lordship. So, my lord, a short date may be given. On last date, Lordship, they have informed that
Pairwise comments have been received.
Heard, Mr. Your good name?
J. Abbas, Lordship.
J. Abbas, learned counsel for the petitioner and Ms. Musare or respondents in secondary education department. Ms. Musare submits that she has not received the instruction to file the affidavit of provision. The price for granting her some time, here is allowed, this is the matter after.
One is, she has already received the instruction, Lordship, in the last order, Lordship.
Fix your lordship.
No, you have received the instruction.
Yes,
Yes,
last
you have
order,
received-
Lordship.
you have received the instruction, but she may be granted some time to file an affidavit to bring on record the said instruction. Where allowed, this is the matter after 1 week.
Lordship, date may be fixed, Lordship.
Okay.
26, 28.
Oh.
22
obliged,
is
Lordship.
same matter.
20, Lordship. Though both same, Lordship, in both cases, interim is there, Lordship.
Okay.
That may continue,
Continue.
Lordship.
Continue in both the matters.
Obliged, Lordship.
23.
The Swarma?
Lordship, here I received a telephonic instruction, Lordship. Till date, the petitioner is claiming that the petitioner is the unmarried daughter of the government servant, Lordship, and till date, that in terms of the PPG department's notification dated 9/8/2018, they have to apply. So that application with all the details has not yet been received by the department. That is the information I have received from the DEO, District Elementary Education Officer. So my learned friend must have to obtain instruction as to whether they have furnished the details for the pension papers in terms of that notification, Lordship. Because it is a claim of a unmarried daughter.
And the other pensioner is lordship, that is also not released.
So, Lordship, my instruction is they have not yet applied, submitted the necessary documents in terms of the notification of the PPG department, which is necessary for the claim of a.
Whether that notification is with you.
Lordship, that notification is not there, only that instruction part is here. I will obtain that.
If possible, file a, give a copy to him so that
Lordship.
he can
yes.
file
Lordship.
the application in proper format.
Lordship.
Heard Mr. L.R. Mazumdar, learned counsel for the petitioner, and Mr. P.N. Sharma, learned assistant counsel for the elementary education department. Mr. Sharma submits that he has received electronic instruction, and as far as instruction, the petitioners have not applied for the pension in proper format, including the relevant documents of which their papers could not be processed. Mr. Mazumdar submits that he may be granted some time to obtain necessary instructions. They are allowed, this is the matter. After 1 week,
Lordship, date may be fixed, Lordship.
28. And 24.
Your Lordship, I am appearing for the office of the Accountant General. On the last occasion, the Council for the Education Department submitted some instructions before your Lordship, stating that the GPF release proposal has been sent to the office of the AG. My lord, and that's why I was directed to obtain instruction with regard to that. I obtained the instruction, my lord, it will speak for itself. This is between the government and the AG and the Education Department, my lord. It says, my lord, the proposal that was submitted is incomplete. So we could not release. May I read it out, my lord? In inviting a reference to your letter dated 17/1/2025 regarding final withdrawal of GPF money in RO subscriber quoted above, I am to state that this office is not in a position to authorize the final accumulation of GPF as the Form A of the GPF withdrawal along with non-royal certificate and last 12-month GPF subscription statement, which are quite necessary for settling a final withdrawal case, are not found enclosed with the papers furnished by your good office. Therefore, you are requested to furnish the prescribed form duly filled in and attested by the competent authority for final withdrawal at an early date for necessary action at this end. And the next page, my lord, is with regard to the accumulated earned leave amount, my lord. With regard to that also, I have obtained the instruction. It says, my lord,
in inviting a reference to your letter dated so and so, I am to certify that Dr. Ramesh Chandra Sutia, retired inspector of schools, Lakhimpur, has 300 days unutilized earned leave on 31/8/2022, that is on the date of his retirement on superannuation, provided he had not availed any leave during his past service with effect from so and so to so and so. Further leave encashment in lieu of unutilized earned leave will be authorized only on receipt of leave, salary, and pension contribution for the period with effect from so and so to so and so from the Assam Higher Secondary Education Council. So we are not in a position to sanction these things, my lord. Unless, my lord, the parent departments, they act in a proper manner, we cannot. So far as GPF is concerned, the entire thing was incomplete. And so far as leave encashment is concerned, that admissibility report we have given, but the authority to, my lord, encash it, that cannot be given without, my lord, that thing mentioned in the last paragraph.
That exposes, my lord, the poor state of affairs, my lord, of the officers of the state, my lord. I am praying for, my lord, my pension before this honorable court, my lord. And this is how the respondents are treating me, my lord. They are so incompetent to submit a report, my lord.
Assam Higher Secondary Education Council.
I'm appealing for the council, my lord. My lord, here, my lord, our authority has made communication to the Accountant General, my lord, on 18/11/2024 and recently on 28/3/2025, my lord. The petitioner was deported by the government, my lord, and his leave records are kept by the government. My lord, kindly finish this.
One department is blaming other, my lord. This is how, my lord, state of it.
So this letter is letter dated 28/3/2025 indicates that he has not availed any leave.
Yes, my lord. Reminder has been forwarded to the Accountant General, my lord, regarding the unleave and any other leave in respect of the.
Mr. Sharma?
28/3/24. Understand what you stated, but if lordship takes up my document, my lord, says further leave encashment in lieu of unutilized earned leave will be authorized on receipt of leave, salary and pension contribution for the period. Probably these things. These records are kept by the government, my lord. If this letter is given to me, my lord, I can obtain the instructions. But it seems that
This is the report in respect of unutilized earned leave. So this report is submitted to AG in the month of March.
We have, my lord, accepted the admissibility of 300 days. Now the authorization to encash the leave amount, that is not provided because of this thing, my lord. Leave, salary and pension contribution for the period. Probably there has to be some contribution, I suppose, what is indicated. That probably has not been by the government. if this letter is given to me, my lord, I can obtain the instruction in next week.
That's all right, but whether it will serve the purpose?
Ultimately, that payment has to be made by the government. And authorization, we have already given that
300 days are there.
300. If a copy of this document can be handed over to me, my lord, I can obtain the instruction from the office of the AG.
So, what is the amount contributed by him has to be given by the government? Or by the board
Yes,
in which he was serving?
yes, madam.
Whether
You are
at any
serving by
point
the,
of time.
deputed by the government and all the leave records are kept in the government, madam. Leave records of the petitioner.
No, no. The amount he has contributed for pension.
Yes, my lord. From
For the
11,
period 11/11/2020
yes, my
to
lord.
28/6/2021.
Yes, my lord.
So you have to furnish that report,
Yes, my lord.
the amount he has contributed.
Yes, sir.
You take a copy, Mr. Soma, you furnish a copy to him, the second letter.
What I have understood, my lord, since he has worked there for probably 1 year. For 1 year, the period of only would be 30 days, my lord. So for 30 days, probably they will have to pay the leave salary. Probably that is the meaning. It doesn't matter whether he has taken leave or not. But earned leave, a person in a year earns for 30 days. So probably that salary for 30 days, they'll have to contribute and the pension contribution. That is probably my understanding, if I'm not mistaken. Every employee, my lord, earns 30 days early.
No, that's all right.
Probably that is the contribution they are talking about. Irrespective of the fact whether the person concerned has availed the leave or not, but that 30 days only would be accumulated into his account. And that 30 days, my lord, salary has to be paid wherever he is employed by the employer.
No, Mr. Sharma, you come to the second letter of the AG office. See the second paragraph.
Further leave, further leave encashment, that paragraph. Further leave encashment in lieu of unutilized earned leave will be authorized on receipt of leave salary and pension contribution for the period so and so to so and so from age.
So this pension contribution has to be submitted by the department.
HSC.
Yes. So you furnish a copy of the letter to him so that he can take necessary steps.
Yes, ma'am. Oh, yes, ma'am.
But Mr. Ijasokia learned talks about the petitioner and Mr. Sharma for respondent number.
Respondent 5 minutes.
Respondent number 5 and Mr.
DK Roy.
DK Roy for respondent number 4. Respondent number 4.
Yes.
And Madam for therapy for respondent number 1 and 2, and Madam Fukan for respondent number 6. Respondent number 6. Person to order dated 22/4/2025, Mr. Sharma has obtained his instruction. Then submits that the GPF money of the petitioner could not be paid as the same was not applied for in prescribed form, duly filled in and attested by competent authority for final withdrawal at an early date. And the leave encashment in lieu of unutilized earned leave will be authorized on receipt of leave salary and pension contribution for the period with effect from 11/11/2020 to 28/6/2021 from the Assam Higher Secondary Education Council. Mr. Roy submits that he will take a necessary step pursuant to the instruction received from the AG office. AG office within a period of 1 week from today. We will release the matter after 2 weeks.
Yes, madam.
Registrar release the matter after 2 weeks. A copy of the instruction letter dated 1/5/2025 be furnished to Mr. Roy during the course of the day.
No,
Some
date
matter
may
of
be
two
fixed.
weeks.
Date may be fixed, my lord.
So the lordship is keeping that instruction on record, no?
Yes. We can furnish on a Xerox copy to you.
Yes, madam.
If it's okay.
4th of June. Oblige.
25.
Mr. Sarkia, yeah, Mr. Sarkia. Mr. Sarkia. You also take a copy of the letter
My lord, that will help, my lord.
and you also follow up the matter.
Oblige.
My lord, on the last purpose, the lordship has right to take instruction, my lord.
Lordship, the instruction is still awaited lordship.
My lord,
Maximum fix after 2 weeks.
My lord, your lordship kindly see the dates, my lord, separate dates and they are retired for 72 years person, my lord. Only a small amount has not been paid, my lord. One is to 39,000 and one is 2,30,000, retired local limited irrigation officer, my lord. And their due promotional benefit has not been paid, my lord. And they are 72 years, my lord. At this lifetime, they may enjoy with the benefit, my lord.
It is an area provisional promotional benefits for a particular
Particular
period.
period.
Lordship. Particular period, not the entire period, lordship.
Clear cut case, my
And
lord.
it appears that that proposal was earlier sent in 2021, lordship. But a non-result certificate is also there, but lordship, perhaps they need to submit the fresh proposal. That instruction I don't have at the moment, lordship. Lordship will fix after 2 weeks. In the meantime, I will obtain concrete instruction, lordship.
My lord, this is a clear cut case, no, lordship, that may fix, my lord.
Promotional benefit of a particular period, otherwise the entire everything is.
Amount is
Even after
You have
lordship,
to pay the interest also.
lordship,
very small amount, my lord.
lordship will fix after 1 week, otherwise lordship I will not instruction.
Heard Mr. S. Rahman, learned counsel for the application, and also heard Mr. Ian Sharma, learned serving counsel for the respondents in elementary education. But Mr. Sharma submits that since I still awaited. And interest for in 1 week time, there is allowed basis and list the matter after 1 week.
My lord, date may be fixed, my lord. 30?
30.
30 minutes. High level.
26.
High level, lordship, high level.
Right, please, your lordship. My lord, in this case, your lordship may kindly see order dated 8/5/2025, your lord.
But I am seeking 2 weeks time, 2 weeks more time to file affidavit. Because earlier, I think the instruction is there, my lord, part of the record. I have received certain instruction that was not sufficient for filing affidavit, my lord. I have asked for updated instruction that has been, my lord, communicated to me. But within 2 weeks, my lord, I will file the affidavit.
Now, the case your lordship will find, my lord.
Okay, we are granting you time, but we will grant stay of the order dated.
Yes.
Stay of the proceeding dated 29/8.
That is already because department is yet to take a decision. The respondent private respondent number 8 has not yet been selected, madam. So it will not affect the petitioner. Granting because he has not been selected, madam. The respondent number 8.
My lord,
Department director is yet to take a
my
decision.
lord, any affidavit is to be filed in this case. It is respondent number 8 because we have challenged the selection of respondent number 8 for appointment to the post, your lordship. And so far government is concerned, your lordship, all these things are matters of record, nothing to be said by the government. So this respondent number 8 is not coming. She knew that she was selected due to extraneous consideration. Petitioner in this case, my lord, petitioner, your lordship will find she passed all the examination in first division. Respondent number passed, my lord, third division. Then she did not have the valid MA degree, so she will not be coming, your lordship. Now the thing is that, my lord, she got the lowest marks, whereas I got the highest mark. I was not selected. And my matriculation, higher secondary, my lord, matriculation, my lord, HSLC first division, higher secondary first division, BA first class, MA, my lord, high second class, my lord, then I have, my lord, the PhD degree. And your lordship will find, my lord, that MA degree, my lord, it is an, my lord, so far as respondent number 8 is concerned. So, my lord, I am going to the facts of this case, your lordship, if lordship permits, your lordship may kindly see.
No,
If
if
one-
we, Mr. Dhar, if we could not dispose of the matter without their affidavit,
My lord, that is the, my lord, I have already stated, my lord, Nasim Banu's case.
so
person-
today we are staying the.
Now, if they do not file affidavit, my lord, despite repeated order passed by the court, that what I am to do, your lordship? I have some urgency. Now, today I am saying that he is overaged. Sometimes, my lord, if times like goes, somebody will say, I am overaged. All these problems are there, your lordship.
Okay, heard Mr. N. Dhar, learned counsel for the petitioner, and also heard Mr. S. Das, learned standing counsel for the higher education department. Mr. Das submits that he has received some instruction, but the same are inadequate to file an affidavit in opposition, and he pays for granting him 2 weeks time. Here is allowed. However, considering the submission of learned counsel for the petitioner and also the submission of the. Mr. Das, learned standing counsel for the respondents in higher education department. It is provided that the interim proceeding dated 29/8/2023 Annexure 8 shall not be given effect to till disposal of this person. List the matter after 2 weeks.
3 weeks, my lord. Then.
2 weeks.
But already, my lord, has stated the.
Maybe.
3 weeks, my lord.
No, 2 weeks.
If you have less.
Respondent number 3 and.
We are for 5 minutes.
5. Petitioner is absent today. None it is for the petitioner on call. How about Mr. Mondal, learned counsel for the respondent number 5 present. List the matter after 19 matter after 1 week.
Since matter is part hard, my lord, I think.
Okay.
Earliest.
1 week.
Obligation.
Item 43, part hard. Or not here, lordship will find. Annexure D, my lord. B, I'm sorry. What page? Annexure D at page. No, I'm sorry. Annexure B at page 18. That is the order of provincialization. Here, petitioner's name appears at serial number 6, and his date of joining is given as 10/12/2007. So clearly, they could not have held that I have not completed 10 years of service, so that that clause will not be applicable in my case.
Yes, Mr. Kaushik.
I've checked as this transfer has been effected by under the Act of 2020.
Yes.
This clause would not be in conformity with section 11. The clause 8, the offending clause, the teacher concerned shall not claim seniority over the existing staff. Because it's, they perhaps have, the authorities perhaps have misconstrued that this is a transfer of.
It's a mutual
request.
transfer. It is for mutual transfer.
Yes.
8 is. Section 8 is for mutual transfer. It is not a case of mutual transfer. It is under.
Even in case of mutual transfer also, this
No, it
section
is not a
11,
case of-
section 11 will be applicable. However, the earlier proposition, prior to enactment of this act was, my lord, as per the judicial pronouncement of this court also, when there is a transfer on own request, one loses his seniority. But that perhaps that proposition will not be applicable, as this is an transfer order under the Act of 2020. So therefore, section 11, the clause 8 of the transfer order is not in conformity in my respectful suggestion. Lordship may remand it back to the Director of Secondary Education.
Section 8, my husband is confused. Section 8 is for.
No, I'm not saying section 8. Clause 8, which is under challenge.
No,
That
clause
clause-
8, because clause 8 will be covered by section 10. No, clause 8 will be covered under section 10. Section 10 provides what are the grounds for transfer. Under what grounds, the following grounds, this transfer can be made. And your authority will find, or the reasons as mentioned in section 7 of the Act.
What I'm submitting, my lord, page 19, my lord. Page 19, my lord.
90.
Page 19. This, the petitioner is aggrieved by this clause 8.
Yes.
That which I am submitting, my lord. Clause 8, that the teacher concerned shall not claim seniority over the existing staff.
Page number 90.
Page 19.
19.
19. This is the offending clause which brought the petitioner before your lordship, my lord. Page 19 of the writ petition.
Yes.
In the top, my lord will find that this is an order passed under the provisions of Assam Elementary and Secondary School Teachers Regulation and Posting and Transfer Act 2020. So the provisions of this act would be applicable for, and
This is
therefore,
applicable. This is applicable.
clause 8, my lord, of this order. Apparently, it appears, my lord, it's not in conformity of section 11 of the act. Section 11, your lordship will find page 16 of this.
Page 16.
Page 16, section 11. The transfer of a teacher made under this act shall not in any way affect his original seniority in the respective cadre of the service.
Yes.
Therefore, my lord, my respect to this clause, it will not withstand the legal scrutiny in respect of section 11. The authorities might have misconstrued it because as it was a transfer on own request, they misconstrued it that once it is a transfer on own request, one loses his seniority. That's that was the proposition laid down by this honorable court. But that proposition will not be applicable as a new enactment
Act
has
has
come.
provided.
Yes.
Act has provided,
Act has
yes.
provided.
Section 10 is clear, my lord. Of the Act. Priority. These are the reasons under which one can apply for transfer.
Lordship will remand it back to the Director of Secondary Education to review this order, my lord, clause 8 in terms of section 11 of the Act.
Yes.
Then
So
your
we
lordship
remand
has
the
made it
matter to
clear.
the director.
My lord,
So do we remand the matter to the director?
Lordship will indicate that section 11, but as per section 11, the seniority cannot be taken away, my lord, cannot be forfeited.
if that is
And
clear, my lord, then
because
I,
Director otherwise has to pass us fresh order, my lord.
then certainly. No, if it is set aside, then if your lordship say this clause 8 is not applicable, ought not to have been made applicable in my case, then it's all right.
It will serve your purpose.
Yes. With that, observation, your lordship may send it back.
Okay, we are not remanding the matter to the DSA.
Madam,
We are setting it aside.
my lord, that will be.
Okay, we'll pass the order.
My lord.
44.
May I please, your lordship? My lord, here, what happened, my lord, by the mistake of fact, my lord, I was placed under suspension, my lord. As to why, my lord, lordship, kindly have a look at page 35, my lord. This was the basic show cause was asked from me for my explanation, my lord. May I read, my lord? Whereas the complaint has been received against you that you are not handed over a copy in relation to the allotment agreement shop number B2 of the supermarket dispute on the account of your personal demands. You are hereby directed to submit explanation to the disciplinary action should not be initiated against you for involved unethical so and so. That, my lord, we have replied at page 36. Now, lordship will see, my lord, page 34. Page 34, it is the document which they are saying, my lord, show cause. Page 34, it is handle and deal by the collector of the GMC, my lord. It is not under my control, my lord. It is by the collector of the GMC whom to give, not to give, my lord. It is there with them only, my lord. Then, my lord, by mistake of fact, my lord, page 37, I was placed under suspension, my lord, which is under challenge, my lord. And as of now, my lord, no review has been conducted, my lord, after expiry of 90 days, my lord. And I'm going to,
You have been placed under suspension.
my lord, I was suspension 18/1/25, my lord. And I'm going to retire of this 31st of this month. That's why, my lord, matter was fixed today for final disposal as per the last order.
So review was not done.
Not, review was not done, my lord, and the suspension was also done by mistake of facts. Because, my lord, the very document for which I have been asked, my lord, in the UMPIN order, it has been reflected also, my lord. Second paragraph, whereas the show cause notice was served against you for submitting explanation being involved in such a unethical and unwarranted process of the workplace by letter dated 9/1/2025. On the receipt of the show cause notice, alleged employee has submitted a written explanation which, however, is found to be not found to be satisfactory enough free from the charges brought against him. Meanwhile, another complaint. Now, my lord, another subject has come. Meanwhile, another complaint has been received from Raja MF citing proof of the providing alleged employee a bribe of 50,000 against demand of 2 lakhs, taking signature on fraudulent paper of the complaint. In view of the above, pending trial of the departmental proceeding, so and so is placed under suspension, my lord. First notice, my lord, they have issued page 35. They are saying something else, my lord. Page 35. They asked, my lord, not submitting allotment letter. That is not my under control, my lord. That is very much there at page 34. It has been issued long back, my lord. 31/12/14 by the controller of GMC. And it was not given to me, my lord. Lordship, kindly have a look, page 34. There your lordship will see again, my lord, copy 2. Chairman, Joint Commissioner, PA, then concerned rent collector, then my lord, personal concern.
Mr. Nayak, you are appearing for the respondent.
Yes, JMC authority.
So whether the suspension order was reviewed within 90 days?
No, lordship suspension order was issued
18/1.
on 18/1, lordship.
And in the next page, Lordship, 10-3 so cause notice was issued. So it was within 3 months, Lordship. So that's why I only need to pass one reason order extending in suspension, Lordship. Now he cannot.
No, whether within 90 days you have passed a region order.
No. Lordship, two conditions as per Ajay Chaudhary, Lordship. If within 90 days search sheet has been issued, then I only need to pass one reason order extending if I want to extend his suspension. In this case, Lordship,
No, that too within the period of 90 days.
no, Lordship. If Ajay Chaudhary is here, Lordship,
Ajay, I'll just clarify, man. Ajay Chaudhary said, my lord, within a period of 90 days, if they file charge sheet, then only, my lord, review is not required. But here in the case, my lord, it was not been reviewed. Nothing has been done, my lord. Simply, my lord, they are throwing responsibility without filing charge sheet, asking for a show cause. That is not that.
show cause is the initiation of
No,
departmental
that is
proceeding.
wrong, my lord. Paragraph 20 and 20. Ajay Chaudhary to aseni.
Lordship, I'm reading Ajay Chaudhary very slowly, Lordship. Lordship, may kindly say just 3 lines, Lordship. We therefore direct that the currency of the suspension order should not extend beyond 3 months. If within this period, the memorandum of search sheet is not served on the delinquent officer employee. So it will not extend beyond 90 days if within this period, search memo has not been issued. That is one condition. In this case, we have issued charge sheet within a period of.
Charge sheet, where is the charge sheet?
Mr. Borbia, let him.
No, my lord, he is making wrong submission.
No. You will get a chance to reply.
The second line, Lordship, that is first part of paragraph 21. Second part is, if the memorandum of search sheet is served, a reason order must be passed for the extension of the suspension. So I am not required to review the suspension. I am only required to pass one reason order if I want to extend the suspension beyond 90 days. So in this case, search sheet has already been issued on Lordship 10/3/2025. He submitted his reply also. Authority said, we are not satisfied with the reply. Accordingly, authority appointed IONPO in this case, Lordship. So now DP is going on. Only one issue remains, Lordship, that is the subsistence allowance. Authority is processing that, Lordship, and very soon he is going to receive the subsistence allowance. But that is the only case, Lordship. I have already received instruction, Lordship. Yesterday I received, Lordship. Lordship, if Lordship directs me or allows me, Lordship, I am ready to file my affidavit also.
I am going to retire, my lord, 31st.
It's up
Hardly 14 days left.
DP may continue even after retirement also.
Lordship will see, my lord, page 38. It is not a charge sheet, my lord. And where is the reason order? Let them show a single reason order that extending or doing something, my lord. That, my lord, I am out of the case. It is not a charge sheet, my lord, mere show cause. It will hit directly, my lord, Ajay Chaudhary judge, because admittedly review has not been done, no reason order has been passed. Now, my lord, after
That a region order has to be passed within the period of 90 days.
within.
No, Lordship. Lordship, if again comes to Ajay Kumar Chaudhary, Lordship.
Ajay Kumar Chaudhary to have. Right. আছে
Lordship, second part, Lordship. First part, Lordship, if within 90 days no search memo is issued, the suspension will not continue. That is one. Second part says, if the memorandum of search sheet is served, a reason order must be passed for the extension of the suspension. So far as the second part is concerned, no time frame is there. It's clear, Lordship. This paragraph 21 direction has two parts. First part, up to 30 days, if I have not issued the search memo, then he will automatically get reinstated. That suspension order will not continue. Second part, If SARS memo has been issued, in that situation, I need to issue one reason order if I want to extend this suspension. For the second part, Lordship, no time frame is fixed.
No, from the discussion made before that sentence.
Yes, Lordship.
Uh,
I'm again reading, Lordship, that two-line, Lordship. We therefore direct that the currency of the suspension order should not extend beyond 3 months. If within this period, the memorandum of charges, charge sheet is not served on the delinquent officer employee. Clear, Lordship, 30 days period, 90 days period, Lordship. If within this 90 days period, I have not issued any charge memo, then suspension will not continue. That is first part. Second part, if the memorandum of charges, charge sheet is served, a reason order must be passed for the extension of the suspension. For the second part, no time period is there. First line, my lord, Lordship will see, my lord, Ajay Chaudhary, right this moment, I do not have the document given again, asylum or judgment. Then, my lord, it. We therefore direct the concurrency of the suspension order should not extend beyond 3 months if within the period of the memorandum of charges charge sheet is not served on the delinquent officer employee. If the memorandum of charge sheet is served, a reason order, if charge sheet is served, then a reason order must be passed for extension of the suspension.
Within 90 days.
That is within 90 days. Sentence is continuing. Between one semicolon is there. This
Lordship, kindly have a look.
see this judgment. This clearly it has two parts, Lordship. First part says 30 months.
No, I have seen it.
Within 90 days, my lord. I have done several cases, my lord. If they want to extend within 90 days, if they don't want to extend within 90 days, automatically reinstate. Complete sentence, my lord. Para 21 and 22 will see, my lord. So I am, my lord, remaining few days, my lord. Remaining few days, my lord, not even 15 days, if today is gone. So let them reinstate me, my lord, DP, whatsoever they want to proceed, they can proceed. But they cannot cross 90 days.
So, is there any other decision to clarify this position?
Lordship.
Is
I
there
got
any
lordship,
other decision?
reserve the judgment, my lord. I'll supply on Monday, my lord. I'll leave, no, lordship is not coming tomorrow. I'll supply tomorrow, Monday morning itself. Lordship can see everyone.
Okay, in the meantime, you file your affidavit.
But I'm praying for just 1 week time, lordship. By this
One
time I'll
week,
be
I have
out of.
received
Yesterday,
The
lord.
person will be retiring.
Lordship, it will not make any difference, lord. Why not, my lord? Also, till the date of retirement, he will get the subsistence allowance. I am not worried about subsistence allowance. So far as DP is concerned, lordship, it may continue even after the retirement, lordship, because it has already been issued.
Then on Wednesday,
Yes.
you file it.
Yes. Lordship.
Heard Mr. Jay Barhoya, learned counsel for the petitioner, and also heard Mr. Nayok, learned standing counsel for the
GMC law.
GMC. Mr. Nayok submits that he has received inspection, then he may be granted some time to bring on record the same by filing an affidavit in the position. There is accordingly allowed, this is Wednesday.
Well, hand over to be made dispose of on that day.
Okay, on that day, an endeavor will be made to finally hear and dispose of that.
My lord, let it be as a part heard, my lord.
No, not part of. Definitely it will be listed.
Apply.
For bail hearing. Numbers 27 and 28. 27 and 28.
Matter may be taken after some time.
After some time. After some time.
Maybe resolution.
29 is all of the same family. That's all three pages.
Lordship, it was earlier rejected on Lordship 7/2/2025 Lordship, page 33. This is the second application on the ground of illegal detention.
Where is the inspection memo?
Lordship, the scan copy is, I have not annexed Lordship. The scan copy is available, Lordship. I have annexed only 48 and 40, 50 and 58, Lordship. Same. Same.
Okay, Mr. Whatever you have gone through the record? Yes, sir. Otherwise, only ground is that, my lord, regarding recent grounds of arrest. Only that, because earlier rejection order, all those grounds were taken. Now, my lord, only ground he has taken that, my lord, no grounds of arrest in writing was furnished to him at the time of arrest. My lord. Only that ground now he has taken. And regarding that, my lord, I would like to point out earlier, my lord, in this case, my lord, arrest of the petitioner or date of the arrest of the petitioner is on 1/9/2023, my lord. So, my lord, if the arrest of the petitioner is on 1/9/23,
Aurora judgment was on?
On three, my lord. That judgment is passed on 15/12/23, my lord. And before that, my lord, the judgment of Pankaj Bansal was passed on, my lord, 3/10/23, my lord.
So your stand is same?
Yes, my stand is same, my lord.
What is your submission in this regard?
In this regard, Lordship, in Bihan Kumar, Lordship, in Bihan Kumar, Pabir Purakasta, Pankaj Bansal, Lordship, the Honorable Supreme Court, Lordship, interpreted the requirements, Lordship. The requirements are there since the enactment.
No, the prospective effect of the judgment.
With regard to that, Lordship, one order of the coordinate bench, I want to furnish, Lordship. Same grounds were taken and opposed by the prosecution side, Lordship, and then thereafter also the order was passed, Lordship. In this case also the arrest of the petitioner 1/8/4/2023, Lordship. And I was arrested on 2/9/2023. Proceed, sorry.
My lord, that judgment itself support paragraph 24, my lord, of that judgment itself, my lord, stated that, my lord, supporting that, in the present case, my lord, accused petitioner, I would just like to point out, my lord. In the present case, the accused petitioner was arrested on 27/23, and therefore the decision of the apex court in the case of Pankaj Bansal is not applicable. Hence, the arrest of the petitioner, accused petitioner cannot held to be illegal, my lord. The present in this judgment, which the petitioner wants.
Okay, you furnish the judgment, we will examine the matter. Order.
Paragraph 45. And regarding, I would like to also point out one other thing. On that day, my lord, my friend pointed out one constitutional bench judgment, my lord, of 1962, my lord. It is Hari Kishan versus State of Maharashtra. My lord, in that judgment, what happened, my lord? That was a case under Prevention Detention Act. There, my lord, the question is not, my lord, regarding grounds, my lord, in what manner, my lord, those grounds of arrest were furnished to the accused person. There, the issue is that, my lord, the accused, that at that point of time, grounds of arrest were furnished to the accused persons, but accused person, as because he did not understand the contents of the same, so he wants that grounds of arrest needs to be translated in his own vernacular language. That is the only issue in that judgment of the, my lord, Hari Kishan's versus, my lord, State of Maharashtra. And thereafter, my lord, regarding the position that earlier, my lord, only grounds need to be informed, there was no such requirement of furnishing information of the grounds of arrest in writing. My lord, in that regard, my lord, Madhur Limaya's decision is also very clear. In that case also, my lord, regarding furnishing of issue of furnishing grounds of arrest was also, my lord, arises. In that case, my lord, what happened? There also, I would like to point out, my lord, what I am trying to point out that at that point of time, existing provision is not the requirement is to furnishing information of the grounds of arrest in writing. Only the requirement is to be only informed about the grounds of arrest. And in that case, my lord, that particular, my lord, ground was also, my lord, not taken by the accused, my lord, petitioner. And in that case, my lord, I would just like to only point out one.
45 to come equal ground, right? 45 to take ground.
Oh, yes. And from the, my lord, reading of the submission of, I would just like to point out one paragraph, my lord. The submission of Madhur Limaya on the second point has already been effectively made on behalf of the state regarding Article 22(2), my lord. Article 22(1) provides that no person who is arrested shall be detained in custody without being informed. My lord, without being informed, as soon as may be of the grounds for such arrest, nor shall he be denied right to consult and be defended by legal petitioner of his choice. So I am only trying to point out that at that point of time, the existing from the, my lord, contents of the other provisions also, at that point of time, requirement is only to inform the accused person about his grounds of arrest. There was no such requirement of, my lord, furnishing information of grounds of arrest in writing. My lord. Now, my lord, every investigating agency, my lord, after doing this, the present position is that, my lord, the petitioner has to be served, my lord, the grounds of information of arrest in writing. The present position is very clear. But before that, Pankaj Bansal, my lord, in case of earlier arrest, my lord, Pankaj Bansal, thereafter, my lord, Ramkishore Ramay clarified that those provisions were prospective. Okay.
You furnish those decisions to court master.
Item 33 for orders.
45, my 45.
No, 45, yes, argued it.
No, I am not raising this point, my lord. This,
No,
my
my lord,
learned friend,
43 is not the same, man.
45.
45 is not same. He is against.
I am arrested on the ground of NBW.
Item number 27, 28, and 29 is same, man.
Yes, 45.
45 minute earlier, your lordship granted bail to the petitioner. During
Yeah,
trial,
there's a default bail.
lordship
No, sorry, it's arrest for default.
arrest for default for 1 day, my lord. Yesterday it was listed. Now I am 44 days behind the bar. 44 days. Okay. So will me
It's a court record.
My lord, in this case, my lord, yes, initially petitioner appeared on 17/1/24, my lord. Petitioner appeared before the trial court thereafter, my lord, on 18/6/24, the petitioner appeared, my lord, with steps. Thereafter, 37/24, 16/11/24, petitioner absent with steps, my lord. Thereafter, on 4/3/25, my lord, accused petitioner, my lord, absent without steps, my lord.
So since 4/3/25, my lord, petitioner,
Only one day he.
only
remained
one day.
absent, Your Worship.
Earlier, my lord,
We had about 44 days.
44 days. And on the strength of my lord, the NBW, my lord, he was later on arrested.
Or Mr.
H.A. Ahmed.
S.A. Ahmed, learned counsel for the accused, and also heard Mr. P. Bartaku, learned additional people for the state respondent. This application under section 483 of the BNSS 2023 is referred by the accused. Who has been referred by the accused? Sariful Islam alias Rabul, who has been languishing in jail in connection with Special Landed Case number 1 of 2024 under section 21B/29 NPPS Act, arising out of Howley PS case number 187 of 2023. What is the earlier order?
It's 17, man. 17.
It is to be noted here that above noted case has been registered on the basis of one FIR lodged by one Mintu Kolita on 5/11/2023. The allegation against the petitioner is that acting on a tip of the informant was intercepted one vehicle bearing registration number AS01 UC 9986 and apprehended two persons, namely Mohammed Rafiqul Islam and Hanif Ali, and recovered one black colored plastic polythene containing four numbers of soft cases loaded with suspected heroin. Suspected heroin. Mr. Ahmed learned counsel for the accused submits that the accused was granted bail by this court by order date 2024 in BA number 51 of 2024. And thereafter he appeared, he was appearing continuously before the learned trial court. But on which date?
4/3/2025.
Or
4/3/2025. He was absent.
or 11,
4/3.
paragraph number. Yes, but on 4/3/2025, the petitioner could not appear before the learned trial court due to his illness. And his engaged counsel also did not take any step for which the learned trial court has issued non-bailable warrant of arrest against the petitioner, and on the strength of non-bailable warrant of arrest, he was arrested on 2/4/2025. And since then, he has been languishing in jail as for last 44 days. To appointed query of this court, Mr. Ahmed, learned counsel for the accused, however, submits that he has not submitted any medical document in support of the ground that the accused was suffering from any illness. However, Mr. Ahmed submits that the accused will appear before the learned trial court regularly, and as such, he may be allowed to go on bail. Support of learned additional PP also submits that on account of default on 2025, the Lordet Trial Court has issued non-bailable warrant of arrest against the accused and he was arrested on 2/4/2025, and since then he has been languishing in jail also. Then what is the stage of trial, Mr. Bortakur?
Evidence. Which on five witnesses examined already, madam.
5 witnesses.
Lordship. Out of 9.
It is submitted at the bar that the learned trial court in the meantime has examined 5 witnesses. 5 witnesses. And taking note of the submission of learned counsel for both the parties and also considering the period of detention of 44 days in jail as well. And also the stage of trial, this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with one serial document with the satisfaction of the learned trial court, the accused shall be enlarged on bail. Trial court means special judge NDPS for the learned trial court will be at liberty to impose any other conditions so as to ensure presence of the accused during the course of trial. In terms of this BS and disposal.
Item 33 for orders.
The respondents have appeared but not filed any affidavit till date, my lord.
My lord, in this matter, after obtaining the RTA, ART and PPG department's view, my lord, it has sent to the finance department now for their views, my lord. This is the instruction, my lord. I have. Moreover, my lord, today I have filed our Kalandama, my lord. So sometime maybe granted.
এখন আছে না মোক ক্লায়েন্টক দেখাব লাগিব না
Heard Mr. Sharma, learned counsel for the petition, and Mr. Sharma, learned standing counsel for the respondent. Mr. Sharma submits that he will file Ukalatnama within.
My lord.
On 10/3/2025, SMC system has appeared on behalf of one
But all
and two.
now has been mentioned.
1 and 2 appeared earlier. On 10/3/2025 order.
SMT 60 appeared.
Yes. How they appear for us? 1 and 2 appear for us.
Yes, my lord. For the respondent number 1, we have going to file the Ukana number today.
1 and 2 already appeared.
Respondent 1 earlier, R. Mazumdar appeared.
Then
1 and 2 is.
on 10/3, SMT 60 appeared on behalf of 1 and 2.
Madam, then no need to mention about the Ukalatnama, but.
Okay. Mr. Sharma appeared on behalf of Mr. SMT 60. Mr. Sharma submits that. One instruction has been received from the Undersecretary, the Dr. Assam, about the school education to the effect that after obtaining views of ERT and PPG department, the school education department moved the file to finance department for their views. And the file is still awaited. And on receipt of the file from the finance department, the department will initiate necessary action. After taking note of the aforementioned instruction, last week or the court today, is provided that recess shall raise the matter after 2 weeks. After 2 weeks, the inspection placed before the court today shall be part of the report.
মানে date may be fixed, my lord.
35.
মানে date.
35.
My lord, this is a contempt case, but I have a serious submission because, my lord, I am retiring in this month. And my case is very good case, and the Honorable High Court passed order asking the director to take a decision within a particular time, but he has not taken. Now I will retire on 31st. So, my lord, I have taken steps also in due time as per your lordship's order.
We are going to file a Galadnama today, my lord. So, my lord, sometime may be granted.
But 31st is the last day, my lord. So let me retire with peace. And she has received it on 29/1/25. And let's see. 29/1/25. So till today, she has got no time to dispose of the High Court's order.
Matter may be fixed on next week, my lord. In the meantime, I will take the instruction, my lord.
Instruction. But not for a moment, lordship, I invite your lordship kindly see page 12. Plus 7. In the event the highest school is a high school, the headmaster of the high school shall continue after amalgamation. The post of headmaster of ME school shall be designated as assistant headmaster with same pay scale whatever they are drawing, and the post shall be held by the existing headmaster of the ME school without requiring the qualification for the post of assistant headmaster.
Mahmood.
However, after
Mr.
cessation
Mahmood.
of service of such assistant headmaster,
Mr.
the
Mahmood.
vacancy shall be filled up from the candidates having requisite qualification.
Let him obtain instruction. He has an instruction to appear.
Yes, they have appeared, but my prayer is only this one, I will retire in this month. So
So
this
that's all right.
official government gives me
We'll,
the right.
We'll take it up on next week.
And Monday it may kindly be
Next
fixed.
week.
by Monday.
Monday will be so short, my lord. So next week, candidates. Friday.
Wednesday.
Let them come with disposal order. If they want a disposal order, I will underpay.
Heard Mr. Mahmood, learned counsel for the petitioner, and Mr. Dev Sharma, learned counsel for the respondents. Mr. Sharma submits that he will be filing his Galadnama during the course of the day, and he pays for granting him some time to obtain necessary inspection. There is accordingly allowed. This shall is the matter of Wednesday. Wednesday, in the meantime, Mr. Sharma shall obtain necessary inspection. You ask them to comply with the order.
36.
Well, in this case, I appeared respond number 2, and I have filed the affidavit also today itself. Probably this is not in record, my lord, copy is there, my lord. Lordship, in by way, my lord, I may be exonerated from this because, my lord, I have complied the order. And probably my friend will have no objection on that, my lord. Because I was the person, my lord, subsequently joining service. On the day of the issuing the order, and that was received by the office, I was not in my chair. So subsequently, I have taken the charge and complying the order, well, I have already written to the director, BTC, for complying regarding to giving the instructions about what do I do. But whenever there are no suggestion was coming, then I have convened the GB, my lord, to comply the court's order, my lord. Because the direction was given to
Selection committee.
to selection the petitioner as a professor of the Assamese department, assistant professor. So my part is I have done, my lord.
till date, Lordship, GB is not going, Lordship, he is, I am not agreed with him, Lordship. Lordship, but like the director, the part of the director, Lordship, kindly see, after receiving the notice, he is not appearing, Lordship. And without the recommendation of the director, Lordship, selection will not be held. And other Lordship, it is from 2021, this is the fourth time cases, Lordship. And in this case also, if Lordship see, page number 15, Lordship, director has not appeared in this case, Lordship. Director has taken the courts, Lordship, leniently in everywhere, Lordship, because it is a not other government, Lordship, BTC government, Lordship. BTC government thinks that the High Court is other part, Lordship. They are not taken this decision, Lordship. The director is ignoring the orders leniently 4 years, Lordship. He is not appearing, Lordship, after the getting notice, Lordship, not in the cases.
Whether notice was served or.
Yes, Lordship, Lordship, earlier order, Lordship, notice was served, notice has accorded. After getting notice, he will not appear, Lordship. He'll not take, but without him, Lordship, they will not, they cannot appoint, Lordship. They make, only they offer that. They have written, Lordship, to the director, that's what to do.
But one thing, my lord.
It is a good case.
I have, my lord, taken the decision, I have issued the letter to the president.
Yes,
To
Lordship.
convene the GB. So after the GB recommendation, director part will come, my lord. So my parties will be, my lord,
Their
to
part
commence
is-
the GB will be there.
Yes.
So unnecessarily, my lord, I should not be dragged in the, my lord, proceeding. Because I have complied, and the day on that which the order was passed, I was not in chair. I came to.
No, I am not against him, Lord. Lordship.
So
After
I
that,
be exonerated, why I should be, my lord?
after GB election, Lordship, his director takes 2 years, 3 years, Lordship. So there is a Lordship, if contempt proceeding is not done up, Lordship, he will not have come, Lordship. Because Lordship, she is not the earlier order, Lordship. He has taken notice, Lordship. He will not appear, Lordship. This is the situation. And
What is your submission in respect of his pair?
Lordship, his pair, Lordship, on 17, no? On 17, he is going to.
Selection when I have
Yeah, he is on 17, he is going to make this Lordship. GB election. Lordship may fix the case after 1 week, Lordship, and if he will produce the, then Lordship may exonerate him. Till today, he has not. Then, but regarding the director, Lordship, contempt proceeding may be finished.
Anybody from BTC?
BTC, I have taken with the BTC council. BTC council have said that they, if no notice has been served to them, Lordship, they cannot appear.
Actually, my lord, this is a
Contempt
case,
proceeding,
so
they
standing
can appear.
council will not come.
Standing
But
council will
the
not come.
concerned person, my lord, he has to engage his own lawyer.
Only he has to engage.
It's a contempt proceeding, my lord.
Contempt proceeding. At least.
Well, one thing lordship can at best, my lord, do, my lord, the matter will come after 15 days. By this time, my lord, everything will be coming with a new, my lord, development also, because the GB will be held on that day by this time. And the GB give the, my lord, recommendation. And on the basis of that recommendation, then this sent to the director. Director BTC will take the decision, my lord. So this will be another development, my lord, every possibility to occur. So, my lord, my prayer is, my lord, after 15 days or 20 days, let me
15 days,
come, my lord.
15 days is better, Lord, yes.
Heard Mr. Dean also, learned council for defense. Also heard Mr. T. Mahanto, learned standing council for.
No, I am not standing counsel. Well, I am the petition, respondent number 2, principal of the college.
For respondent number
Sir,
2.
principal.
Respondent number 2. Mr. Mahanto submits that he has a file is
Affidavit in reply.
affidavit in reply. Affidavit in reply. And he applies for exonerating the respondent number 2 from this contempt proceeding. We are taking note of the submission of learned counsel for both the parties. It is provided that this is the matter on.
Well, one thing, my lord, the affidavit probably this is not in record, so director may be given to the registry to bring the record in this.
Plus record the affidavit filed by respondent number 2.
Oblige, Lordship.
37.
May I brief, Lord? As per office note dated 34, respond number 1 and 4 are served. And they have appeared. And 2 and 3 also served, but they are yet to make appearance.
Heard Mr. A. Patasari, learned counsel for the petitioner and madam for.
I'm appearing for respondent number 4 on behalf of D. Nath.
Respondent number 4 on behalf of D. Nath, learned senior government. And Mr. S. Dash for respondent number one. Non-appeals for respondent number 3 and 4.
Yes,
When
2 and 3.
You got 3.
I am for 4.
4. Non-appeal. Non-appeals for the respondent number 2 and 3. So, office not dated. 21/4/2025 indicates that AD card in respect of respondent number 2 and 3 returned with a report. Place the matter after 1 week.
Fine.
After 1 week, in the meantime, counsel for the respondent number 1 and 4 shall obtain necessary instruction.
Can a date be fixed, man?
After 2 weeks, my lord. After 2 weeks, my lord. The partially has been complied with.
Of that?
638. Much lord.
May please. In this case, Lordship, notice has been served, Lordship, that report is not in discussion.
So neither ethical nor.
No,
ethical is written.
it.
Heard Mr. Mohanto, learned counsel for the office not dated 2/5/2025 indicates that neither ethical nor answered notice is returned. Return to the section till date. You want to take process then? Or will await service report?
Lordship, I may wait.
Await.
If Lordship permit Dusty, Lordship, I can, because it is a commissioner, Lordship. I think 1 month. Lordship.
Mr. Mohanto submits that he may be granted permission to pause, to effect service upon the respondent by Dusty. We are allowed after effecting service upon the respondent by Dusty, Mr. Mohanto shall file an affidavit to this court and next second. There is a matter after 2 weeks.
Lordship.
49.
Your Lordship, I'm appearing on behalf of my senior, A.R. Borua.
Who?
A.R. Borua.
A.R. Borua.
Avinash Borua.
Mr. Yeah, you are appearing for
1 and 2 lots.
1 and 2.
Your Lordship, I beg to mention, respondent number 4 and 5 have notice has been served to them.
Service complete, Lordship, as per the laws in order services.
Heard, Mr. Your good name, please.
MJ Hazarika.
Learned counsel appearing on behalf of Mr. A.R. Borua. Learned counsel for the petitioner and Mr. Bhuya for respondent number 1, 2, and 3. 1, 2, and 3. Office note dated 5/5/2025. The order of the Lausian Court dated 5/5/2025 indicates that service in respect of respondent number 4 and 5 completed. Accordingly, it is provided that SSL is the matter for admission hearing after 2 weeks. In the meantime, the respondent authorities may file their affidavit in opposition. After 3 weeks, after 3 weeks. But the respondent number 4 and 5 remain unrepresented today.
46.
My pleasure, Lordship. IA number 1252/25. A file objection, Lordship. So, Lordship, I may be allowed to file affidavit in reply, Lordship, against the objection. And in the meantime, I am got transferred, Lordship. So, Lordship, till that I may be stayed because I am transferred to Simla. So, for filing this reply, so I have to stay here, Lordship. Because last prayer, Lordship, I have also prayed on last occasion, Lordship, on order dated 34/2025, Lordship. Here I have already submitted before, Lordship, and order is also there, Lordship. I may read out the order, Lordship.
Transfer order is not under challenge, my lord. He has not challenged it,
Lordship.
and on 9th of May, he is already released from the from Guwahati, my lord, from Zonal Office. He's already released on 9th of May. So question of staying that does not arise.
No,
And,
that will-
this transfer order is not under challenge, and there is no pleading to that effect also, my lord. Can you see the IA he has filed?
But in the meantime, I have been transferred from 2 times, Lordship. January, I am transferred to zonal office. From zonal office, again, I am transferred in March, Lordship. So in the month, within 3 months, I am transferred because I do not know while filing this writ petition and I already in my transfer in the meantime. So there is a difficulty, Lordship. So in the meantime, till,
You challenge the transfer order in a different form.
but I'm already released, Lordship, on 9th of May, Lordship, what to do, Lordship. Okay, I have to go only. So till filing of this affidavit reply.
No.
Is it possible?
Prayer is not there in the main writ
No,
petition. How can
nothing.
he grant us relief?
Lordship. So at least 3 weeks time will be allowed, Lordship, to file affidavit reply in the IA.
Heard, Mr.
G does.
He does learned counsel for the petitioner and Mr.
SK Chakraborty, my lord. SK Chakraborty, for the respondent FCI.
For the FCI.
FCI.
Mr. Das learned counsel for the petitioner submits that the respondent have filed their affidavit in opposition and the petitioner may be granted some time to file affidavit in reply. Now reply to the aforesaid affidavit in opposition. Here is accordingly allowed, the SSL is the matter after
3 weeks.
3 weeks.
My lord, this order may passed in IA. In
IA,
case
Lordship. In case there is not
In the
filing.
main case, my lord,
IA.
yeah.
In IA also.
In main case, you have not filed it.
Not filed, yes, not filed.
Because there is a direction to file at least the objection in the IA by 14th. That is why we have filed the IA objection by on 14th of this month.
Okay.
Only.
Item 1 of production list, ISBL 1533 of 25.
Wait, please. Well, before your lordship takes up the IA, my lord, to kindly take the connected contempt petition, my lord. The order which has been alleged to be violated, my lord. There's a allegation of contempt. Is page 31. May I just read the order, my lord?
No, what is the ground for filing this IA?
My lord, the order which has been the direction of this honorable court has already been complied, my lord. May I just read the order first, my lord, against which the allegation of contempt is leveled, my lord. It's a twofold direction, my lord.
Oh, no, on the other day, who appeared in this matter?
My lord, Mr. Sharma appeared. Possibly, my lord, that this was not brought to your lordship's notice, my lord. The direction of this honorable court. What
No,
was the
no, no,
direction?
no, that was yes, brought to the notice of this court.
In my respectful submission, my lord, in contempt jurisdiction, my lord will have to see that whether the direction is complied or not. My lord.
How, no, court has also to see how the direction is complied with.
Yes. How? No, my lord. There's a judgment of the Supreme Court, my lord, which says the correctness of the order cannot be looked into in the contempt proceeding until that direction. Because here, my lord, the direction your lordship will kindly allow me to read, my lord, the direction.
No, 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 on the other day we have read it.
No, my lord, page 33. For a moment, my lord.
On the other day, we have read
We have
it,
filed our affidavit
and,
also, my lord.
we have also asked him to obtain instruction. He obtained instruction. And his instruction is that
That there was
word
no
is
enrollment.
Enrollment,
There was no enrollment.
not the.
Now, my lord, the
students
director,
appeared.
yes, my lord, the direction was to the director. Now, director under the statute also does not have any power to go beyond what has been decided by the state level committee.
That's okay.
Therefore, my lord, your lordship will kindly allow me to read the
No.
page 33, my lord.
No.
Or your lordship may record my submissions.
No.
And my lord will pass order, my lord. My lord, your lordship will kindly allow me page 33.
No.
Just for a moment, my lord.
No.
For
no,
my
no.
satisfaction, my
No,
lord.
on the other day, we have read several times.
No, my lord, may I just impress, my lord, your lordship will allow me to at least make my submissions, my lord. Page 33, my lord, will kindly see.
No. What remains there to hear you? If the statute provides for enrollment, then you are interpreting as the number of candidates appeared in the examination.
No, my lord, as it is a contempt, my lord, in my respectful submission, my lord, as it is a contempt, my lord, what is the direction to the director, my lord?
Sorry.
Direction to the director was to place before the SLC within 3 months. That was the only direction. And within 3 months, 5th of January 2024.
Okay, we will hear you on next week. Heard Mr.
Well, there's a
Kaushik
direction
Learned
for personal appearance of the director on Monday. What I'm praying for.
Learned counsel for the applicant. Issue notice to the opposite party.
We have already served a copy to him.
Place the matter on.
The main matter is.
File a petition on that day, we'll see.
Well, 19, there is a direction for appearance at 2 o'clock.
Okay. On
Well,
that
what
day,
I'm
we'll file
at this stage, what I'm praying for, my lord will dispense the personal appearance on 19. Your lordship will hear me on 19. Your lordship will take a call whether personal appearance or contempt.
You serve notice upon the other side. We'll see.
Then my lord will dismiss his application because it will become infructuous on 19. My limited prayer for is dispensing the personal appearance.
You file an application on that day, we'll see.
My lord,
Other matter.
or your lordship will keep this matter pending for 19th? Because what my lord will kindly hear me for. What my prayer in this application? Dispensing the personal appearance on 19 and take into consideration the affidavit filed by the respondent.
You served the notice?
No, notice is already served, my lord. They have received the copy.
Behind the back of the other side, we will not pass it.
No. Even, my lord, it's a contempt proceeding. It is always between the respondent and the court.
Maybe.
And the petitioner has been served, my lord.
The way the respondents try to circumvent the order of the court, we will not consider it.
My lord, in my all respect and humiliation, my lord.
Sorry. The next item.
Timing item 27-28.
Lordship is fixing a date.
After 1 week, we'll see.
Both the
You
contempt
served
and
the
the
notice.
19, the contempt matter is fixed.
Okay, on 19 then.
19. Matter, this application may be kept pending. The lordship will take into consideration the application on 19 May.
Timing 27-20.
27.
Yes.
Yes, my lord, on the last occasion, my lord, one issue, my lord, was raised by the learned public prosecutor, my lord, as to whether the judgments in Vihan Kumar had prospective effect or retrospective effect, my lord. In that regard, my lord, the learned public prosecutor had also placed certain judgments, my lord. So, my lord, regarding that, my lord, the lordship wanted to know my submissions, my lord. Regarding the point as to whether the judgment as to furnishing grounds of arrest in writing, whether this law has prospective effect or retrospective effect. Because in this case, my lord, the arrest was made on September of 2023. That is prior to coming of the judgment in Prabir Purkas, Pankaj Bansal. So there it was his submission that since Pankaj Bansal had prospective effect, so I will not get the benefit since the arrest was made prior to Pankaj Bansal's judgment. So on that point, my lord, I was to make my submission.
Yes.
Yes. So if your lordship has the judgment of Pankaj Bansal, my lord. But my humble submission is that, my lord, Pankaj Bansal was dealing, if your lordship will kindly see para number 16. Para number 16. Pankaj Bansal, my lord, the Supreme Court was dealing only with regard to section 19 of the PMLA Act. Para number 16. Fourth line, my lord, the only issue. The only issue for consideration presently is whether the arrest of the appellants under section 19 PMLA was valid and lawful, and whether the impugned orders of remand passed by the learned vacation judge, session judge Panchkula measure up. So in that regard, because section 19 PMLA says that as soon as the arrest is made, thereafter the grounds of arrest has to be furnished. Now, whether those grounds of arrest has to be furnished in writing or not, that aspect was considered by the Honorable Supreme Court, and placing reliance on Article 22, the Supreme Court came into the finding that yes, that it should be communicated in writing. Thereafter, my lord, Ram Arora judgment came up. Ram Arora judgment was also placed, my lord. Ram Kishore Arora. Ram Kishore Arora, my lord. There, my lord, it was held that yes, the findings of Pankaj Bansal has prospective effect because it started with the line that henceforth in all such arrests, the grounds of arrest will have to be furnished in writing. My humble submission is that both Ramkishore Arora and Pankaj Bansal were dealing exclusively with regard to section 19 of the PML Act, because the court tried to amplify as to whether in case of any arrest made under section 19, the grounds of arrest has to be furnished in writing or not. But with regard to the general application throughout all the other acts like NDPS or BNS or IPC, my lord, the root source of law is Article 22. Article 22 has been drawn by the Honorable Supreme Court to say that yes, the grounds of the arrest has to be furnished in writing. Now, my humble submission is that, and regarding interpretation of Article 22, the Supreme Court relied on a judgment of 1962, Harkiran death judgment, wherein it was dealing with 22(5). The Supreme Court drew a corollary that
No, that was also in case of one preventive detention under the case of preventive detention act.
Yes. So my humble submission is that
If you want to distinguish the matter by saying that this is under PMLA,
yes,
and that is under this preventive detention act.
Yes. So my humble submission is that
And as such, it is not applicable.
Yes.
In the case.
Yes. Yes.
No. There, in both the cases, in all the three cases, Supreme Court has, or what Supreme Court has discussed about the provision of 22(1) article.
Yes.
Then?
Yes. So my humble submission is that regarding regarding interpretation of the Constitution, article of a Constitution, my lord, whether we can say that it only has a prospective effect because the Supreme Court is not adding any word to the article, or the Supreme Court is not interpreting any amendment of the article. That article was there since the Constitution was adopted.
And regarding that, my lord, this judgment, this Kanishka Singha judgment, it is also clear that whenever there is any judgment, the
Which judgment?
Kanishka Singha, my lord, that was also perhaps placed. Kanishka Singha.
No, that was not placed.
It wasn't Kanishka Singha. So, Lordship will kindly see para number 3. Now the law of prospective and retrospective operation is absolutely clear. Whereas a law made by the legislature is always prospective in nature, unless and it has been specifically stated in the statute itself about its retrospective operation. The reverse is true for the law which is laid down by a constitutional court or law as it is interpreted by the court. So this judgment says that any kind of interpretation made by a constitutional court, unless and until it is specifically stated it has prospective, it will be deemed to be have a retrospective operation. But with regard to interpretation of a constitutional provision, we cannot say that Article 22(1) shall be looked at from like this way from today or from a future date. Article 22 was there, my lord, since the inception, my lord, of the Constitution, my lord. So the Supreme Court are now only saying that yes, Article 22(1), the grounds has to be communicated in writing. That was what was interpreted by the Supreme Court, and that is the source of the law in all these judgments, ma'am.
You tell me whether in the Constitution, in Article 22(1), it is stated that the grounds should be communicated in writing?
No,
Then,
that was interpreted in all these judgments.
then
Yes. That is what I am trying to say, my lord. The grounds of whether it has to be communicated in writing or not, that part was interpreted by the Constitution, by the Supreme Court in all the judgments from Pankaj Bansal onwards.
no, you tell me whether this decision in Ramkishore Arora,
Yes,
the observation made in paragraph number 23,
yes,
that the henceforth, where
yes,
the word henceforth was interpreted,
yes,
is not applicable in the present case.
yes,
That is the question.
yes. My humble submission is that Ram Kishore Arora was explaining.
No, your simple oral submission will not do. If you have any authority, you show me, we'll consider it.
But I have to check the, my lord.
Yes, you check it.
Yes.
My lord, regarding Kanishka Sinha judgment, was my learned friend trying to point out regarding prospective and retrospective effect of the, my lord, Constitution and the judgment of the Honorable Supreme Court and the, my lord, various act and the provisions of the statute, my lord. In the judgment of the Kanishka Sinha itself clarifies the provision which, my lord, specifically mentioned if the, my lord, in the Pankaj Bansal judgment, Pankaj Bansal my lord, specifically itself stated that this judgment will be applicable prospectively by using the word henceforth. The same thing was, my lord, words was strengthened by the judgment of the Ramkishore Arora. And my lord, regarding Kanishka Sinha judgment, regarding prospective and retrospective effect of the, my lord, constitutional authority, I would like to point out again that from that paragraph, my lord, the only relevant portion, my lord, the judgment of the court will always be retrospective in nature unless the judgment itself specifically states that the judgment will operate prospectively. So, my lord, here.
Which paragraph you are reading?
I am reading in, my lord, paragraph 3 of the Kanishka Sinha judgment, last portion, my lord. Page 2, from the last line, the judgment of the court will always be retrospective in nature unless the judgment itself specifically states that the judgment will operate prospectively. The prospective operation of a judgment is normally done to avoid any unnecessary burden to persons or to avoid undue hardships to those who had bona fidely done something with the understanding of the law as it existed at the relevant point of time. Further, it is done not to unsettle something which has
which has long been settled as that would cause injustice to many. And for that reason, my lord, Pankaj Bansal itself specifically stated by using the word henceforth that this judgment will be applicable prospectively. And the same was, my lord, further strengthened by the judgment of Ramkishore Arora. And the same thing was also, my lord, hereby from this judgment also reflects that, my lord, to avoiding all such type of, my lord, complications, my lord, that the judgment will my lord, take effect prospectively. So everything clarifies, my lord. And my learned friend trying to argue that already what is there in the provision of the article of the constitution, my lord, that was, my lord, later on I myself, my lord, argued from since the days, my lord, in all earlier cases. Yes, the provision is there in the constitution since earlier. Supreme Court recently has clarified. Now position is clear, my lord. But, my lord, before that, what happened, Pankaj Bansal, I am arguing only on that point. And that point is also from the judgment of, my lord, Pankaj Bansal, Ramkishore Arora, and from the judgment cited by my learned friend Kanishka Sinha regarding prospective amenity. Everything clarified, my lord. There is nothing to argue on that point, my lord. Those judgments itself clarified the provisions, my lord. And regarding, my lord, other arguments, it is very difficult for us to, my lord, make many of the arguments because Supreme Court, after clarification of the Supreme Court, sometimes some of the points, it is also difficult for us to argue on many points, my lord, because after, my lord, settling all those issues by the Supreme Court, our, my lord, line of argument is very limited now. So within this limited, my lord, point, my lord, I will try to point out before your lordship that, my lord, and, my lord, considering all these NDPS cases, my lord, these are, my lord, very serious, heinous offenses, my lord. How the society is, my lord, going to be affected, my lord. And regarding, my lord, recently one Supreme Court judgment is also, my lord, pending. I would just like to one pending that judgment not yet, my lord, judgment is reserved, my lord. What Supreme Court has, my lord, that is recently, my lord, that was in that I would like to just point out on the paragraph 14, my lord. In that view of the matter, by way of an ad interim order, we are inclined to release the.
Okay, Mr. Bortakur.
Yes, ma'am.
Let him do research.
Yes, madam, one
You find
addition, my
anything,
lord.
you can
Yes.
produce it on next,
Yes,
next day.
one more addition, my lord. My lord, Pankaj Bansal was dealing with 19 of the PML Act. Prabir Purkayastha was dealing with 43 of the UAP Act. As to whether those grounds of arrest which was mentioned in these provisions, my lord, were to be communicated in writing. But regarding section 52 of the NDPS Act, it is a similar provision, my lord. It says that any officer arresting a person under section 41, 42, 43, 44, as soon as may be, inform him of the grounds for such arrest. So there is no such judgment on this, my lord.
No,
So
no,
here you also word is, my lord, informed.
Yes, so
It is not your case that you have not been informed. You have been informed. but,
yes, so
not in writing.
yes, so that writing part will come from Article 22. So my simple understanding is that
No,
yes.
in the Article 22(1) also, it has not been provided that it should be communicated
Yes.
in writing.
Yes.
And, my lord, Madhu Limaya's judgment in, my lord, 1969 judgment, Madhu Limaya's
Anyway,
judgments also regarding this point, my lord.
Let us adjourn the matter.
Yes,
In the meantime, you search it.
my lord.
If within the parameters of the legal framework, we are ready to grant you the relief you are entitled to.
My lord.
But that should be within the
My
parameter.
lord.
Heard Mr. Das, learned counsel.
I have provided all the judgments.
Thank you, then also heard
Take care,
Mr.
Lord.
P. Bortakur, learned counsel for step respondent. This is the matter on
After 1 week.
Tuesday for further hearing.
20.
Okay. In the Thakur's matters also, we will hear you.